Hey everybody, if you're coming in, we are doing the consolidated case Louisiana Robinson versus Callais, and we're still waiting right now. Let's see. They're testing everything, so it's gonna be a minute. I'm hoping y'all can see the background. TikTok is on some shit and it like expanded my background without my consent. I'm not here for that. But yeah, we're doing the first one. We're actually doing two today. It's going to be the consolidated re-argument in Louisiana versus Callais, and then they added the Robinson case in and consolidated it all for arguments. So we shall see what is going to happen today. Oh, they'll be on soon, but yeah. I hope we're all ready for this. It's going to be interesting. Like, so there's some fundamental things that play here. There is Section 2 of the Voting Rights Act. There is the, sorry, I'm trying to get this adjusted so I don't look like, you know, rough. I should have done something with myself today, but anyway, so why is it okay? It's live. You've got the 14th Amendment right, which is the equal protection under the law. This court has been more than willing to reaffirm, at least through a few different decisions, that while I think the original intention of equal protection under the law isn't the way that this court sees it, they're like, hey, white people are being disenfranchised. So you've got this case going on. I feel like it's going to be fairly interesting. They're saying essentially Louisiana backed out of the argument, just so we're clear. Louisiana ended up backing out and they were like, nah, we're not going to do this anymore. However, the black voters are still saying this is not racial gerrymandering. I think when I read the numbers, it's about 1/3 of Louisiana are black voters. You know, we deserve to have these two congressional districts. So this is going to be a very interesting case. No, I don't believe that I speak for people of color. I simply think that I am stating what's going on in this case. That's all it is. Okay, let me refresh real quick. What's something going on? It's weird that like I'm not getting anything yet. Let's see. This case is pretty interesting as far as it goes within terms of gerrymandering. Can states basically do what they want with their maps and disenfranchise voters, particularly voters of color, or can they, or are they held to a bit of a different standard? So I want to see how this is going to play out. Delays in their lives. Yeah, I agree. But yeah, there's some really good stuff on Scotus blog about it. So if you're wanting to kind of update yourself on where this case is at, where it's going, you're welcome to go over there. I usually try to, come on a little bit early and read sort of some of the stuff, the comments on the case. However, I was running behind today, so sorry about that. This is not the only question that they will be looking at, but this is a sort of synopsis. Sorry, guys, it's taking a minute. Let me see if any, like, YouTube has the feed up yet or anything. YouTube oral arguments. Supreme Court today. the ex post facto bullshit. We'll try it again. What the hell? Usually they do more than one test, but let me see. Let's see, Robinson v. Callais. Oral argument. Listen. Oh. Okay. Okay, so yeah, I'm checking live coverage. They don't have anything yet either. So, you know, this is really sort of what did the Voting Rights Act protect? Oh, here we go.
Argument first this morning in case 24-109, Louisiana versus Callais, and the consolidated case. Ms. Nelson.
Thank you, Mr. Chief Justice, and may it please the court. A mere 2 years ago, in Allen versus Milligan, a case nearly identical to Robinson, this court noted that under certain circumstances, it has authorized race-based districting to remedy state districting maps that violate Section 2. Louisiana affirmed findings that, six appellate judges affirmed findings that Louisiana, in the face of extreme racially polarized voting, packed and cracked Black voters, and it rejected 7 non-dilutive maps in favor of one that would give its 58%
if you don't know what packing and cracking is, please go look it up.
Entrenched control over 83% of the congressional
It's how they gerrymander you.
Louisiana's creation of a district to remedy that discrimination and to ensure that Black Louisianans have an equal opportunity to participate in the process is constitutional. Precedent from Brooks to Milligan, from Ex parte Virginia to SFFA confirm that. And 3 facts guard against indefinite use of race. First, not all Section 2 remedies center race. Second, when racialized politics and residential segregation wane, so will the ability to satisfy jingles. Third, almost every redistricting map is replaced decennially. My opponent's late-breaking and recordless facial and as-applied challenges seek a staggering reversal of precedent that would throw maps across the country into chaos.
Fact.
If SB
Illinois
is unsatisfactory,
rates in the system as the most highly gerrymandered map in the country. Yes, Illinois.
That address the Section 2 violation and satisfy the Constitution. As this court noted in Milligan,
nope,
Congress
not Texas,
is
Illinois.
Undoubtedly aware of Section 2 precedent and can change it if it likes. But unless and until it does, statutory stare decisis counsels staying the course. I welcome your questions.
Counsel, what was the finding or the holding in Robinson, and what role does it play in the SB 8 map creation?
The finding in Robinson was that there was a likelihood of succeeding in a Section 2 claim, proving that the state of Louisiana violated Section 2 by packing and cracking Black voters. So there was a Section 2 liability finding under a preliminary injunction, and there was an ordering of a new map to be drawn.
What is the status of that case now?
Robinson is concluded, and there's now, as we know, the challenge in Callais that suggests that their map that was created out of Robinson, SB 8, is a racial gerrymander, and that's why we're here today.
So SB 8 was the remedy for the Robinson case. I thought that was a preliminary injunction.
Yes, there was a preliminary injunction indicating that we were likely to succeed if we continued to pursue a claim. This is after a 5-day hearing with 21 witnesses and a robust record. So the court found, based on that evidence, that we were likely to succeed on liability, and ultimately instructed the state of Louisiana to draw a correct and constitutional map.
But there was never a full merits determination.
That's correct.
SB 8 was entirely separate, though, from that
Yes,
litigation.
it was.
SB 8 came after the litigation. It was in response to the court's order to create an opportunity district and a second map that would cure the Section 2 violation.
But did the court order this particular map?
No, the court gave the state of Louisiana an opportunity, as this court has suggested it do. It gave it
So
broad
the court
discretion,
just
gave it
basically
wide
said,
latitude
"Fix
to
it."
create a map that it felt was satisfactory, and ultimately that is the map that was in effect and elected a congressional delegation in 2022.
Counsel, you began with Allen against Milligan. That case, of course, took the existing precedent as a given and considered Alabama's application of its approach to the evidence and all that under that precedent. Is that your understanding as well?
That's correct. In fact, the case was stayed because this court held that case in abeyance until it decided Milligan, because it understood Milligan to be important to understanding the case in Robinson.
But it was a case in which we were considering Alabama's particular challenge based on its what turned out to be an improper evidentiary showing.
Thank you for coming in. Thank you for the likes and follows.
In other words, we were looking at Alabama's suggestion that how to apply its body of evidence or which evidentiary considerations we should take into account under the existing precedent.
That's correct.
Thank you.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant.
This is
or
Jackson.
the fact that we held or what we held in that case is relevant to what we're doing here today.
Allen versus Milligan is a nearly identical case. There was a similar challenge that where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that the results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a...
Real quick, for people wondering what the Jingles criteria is, it's Thornburg versus Jingles. It's a 1986 case. I'll read you the 3 criteria. It provides 3 criteria for proving that a voting practice illegally dilutes minority votes. Compact and cohesive minority. The minority group must be large and geographically compact enough to constitute a majority in a single member district. Political cohesion. The minority group must be politically cohesive, meaning they tend to vote similarly. And majority block voting, the white majority must vote sufficiently as a block to usually defeat the minority group's preferred candidate. Sorry about that. I wanted to pause.
Protection has been considered a traditional districting criteria. However, we know that protecting an incumbent, like core retention, can continue to perpetuate discrimination. And it does not trump the anti-discrimination principle.
All right, if incumbent protection is a permissible districting criteria, then under
this is Alito.
Rucho, isn't seeking partisan advantage also an objective that a legislature may legitimately seek?
Not if it comes at the cost of the equal protection principle and the 15th Amendment's prohibition on race discrimination in voting. It is not.
Well, if the objective is simply to maximize the number of representatives of a particular party, that's
a good one,
seeking
Dave.
a partisan advantage. It is not seeking a racial advantage. Isn't that right?
Well, if race is used as a means to seek the partisan advantage, then that is unconstitutional.
Oh, sure.
There's
sure.
no
If race is used as a proxy for partisan affiliation. Let me ask you a related question about block voting, which is the second
So just update.
figures in the second and third Gingell's precondition. If registered Democrats overwhelmingly vote for Democratic candidates, regardless of the candidate's race, is that block voting?
If you're looking at it simply from a party perspective, no, we don't judge block voting based on party. We judge it based on race. Racially polarized voting is measuring racial performance and voting behavior.
And likewise, if registered Republicans overwhelmingly vote for Republican candidates, that's not block voting.
That's not how we measure voting. We measure voting based on race for purposes of Section 2 because the Constitution forbids race discrimination in voting, not party discrimination.
All right, so if it happens to be that people of one race or another race overwhelmingly prefer one of the political parties, does that transform the situation into racial voting, or is it still just partisan voting?
No, you look at how different races of voters vote and whether they vote in a way that is polarized. And the Jingles test requires us to look not only at that, but a number of other features
gonna
as
be
part of
Section
the totality of
2,
the circumstances
Part
test
B
that suggest that race is playing a role
of the Voting
to
Rights
contaminate
Act,
the
if you're
electoral
keeping up with
process
this.
and
Section 2,
submerge
Part
minority
B.
votes in a way that violates the Constitution. So party cannot explain
It's going to present an interesting
away,
challenge to this.
a racially polarized circumstance unless we look at the totality of the circumstances. And I will say, in Robinson, for example, the court entertained testimony along those lines, as it did in Milligan, and found that it wasn't credible, that the extreme racially polarized voting that we have in the state of Louisiana cannot be explained away by party. We're talking about racially polarized voting that is above 84%, which is more than what this court found in Thornburg versus Jingles in 1986, and the numbers were 7%.
That could be easily analyzed by statistics to see whether whether white Democrats vote for black Democratic candidates at a lower rate than they do for white Democratic candidates, whether white Republicans vote for black Republican candidates
This
at a
is
lower rate than they do for
Alito
white
busy
candidates. It's easy
ignoring
to
the
isolate race
dichotomies
from
that like
to
race
see whether there
plays
really is
within
racially
voting.
polarized voting, as opposed to partisan polarized voting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not.
Holy
and
shit.
we know that there is such a significant chasm between how black and white voters vote in Louisiana that there is no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 25 of its
Thank you,
brief
everybody coming
that
in. If you can
the
like
court
and
should
share
hold
and
that
tap and all the
plaintiff's
goods.
illustrative district cannot disregard the state's political objectives. And goes on to say, Section 2 plaintiffs cannot claim a lack of equal openness where politics rather than race is the likely reason for the state's refusal to create a majority-minority district.
Yes, that suggestion would swallow Section 2.
It was.
As I said, party cannot trump the responsibility of states to ensure that all voters have an equally open electoral process. The
They can't be
fact that
unduly
Black voters
disenfranchised.
may correlate with voting Democrat or white voters may correlate with voting Republican does not deny the fact that there is racially polarized voting, and the totality of the circumstances, including the inability to elect Black candidates in Louisiana on a statewide basis for a number of offices. There's never been a Black person in Louisiana elected statewide, is additional indicia that race is playing an outsized role in the electoral process in Louisiana.
That
And so
can
the
be
idea
speculative,
that
though. I wouldn't have offered
have
that.
to show that party is the reason for the racially polarized voting would eclipse the entire Section 2 analysis, which is focused on ferreting out and ending race discrimination in the political process.
You said several times that it's playing an outsized role.
That's why I
Is there-
wouldn't have offered it.
What's the proper size? In other words, is that wiggle room we're talking about, or a significant percentage? What is meant by
Sorry,
outsized?
So this court has held for a
Driving me
long
crazy.
time, beginning in Shaw and in many cases since,
Thank you
that
so much.
there's always an awareness of race. There are always racial considerations and even race consciousness in the districting process. What becomes potentially unlawful is when race is the motivating factor. That's what Miller versus Johnson taught us. That's what Milligan reaffirmed, that the line between the appropriate use of race and the use of race that will get us into the strict scrutiny territory is the dividing line between motivation and general awareness. And what I'm explaining.
Sorry, I want to be clear because she's kind of getting explanatory. I want to be clear for the people coming in. If you are not informed on racial gerrymandering, the Jingles case, if you have no idea what redlining is, this is not the case for you to watch right now. I really want you to go look that stuff up and then come back to us.
Asked to consider the totality of the circumstances. If I may address the durational limit question, which came up, I'd like to talk about the fact that Section 2 is self-limiting. I know that there is a general concern about the indefinite use of race, and there are several reasons why that concern should be allayed. First and foremost, there is no precedent to suggest that a statute must dissolve on its own simply because it may require a race remedy. And as I've mentioned, race is not required by Section 2, but it can be used if that is necessary to address the Section 2 violation. In addition, the non-discrimination element of the 15th Amendment is a permanent right, and so should be the
Derek,
protection
that
that
one
Section
was
2
more
affords.
the legal
And finally,
challenge that they
this is a
offered
significant
wasn't the same one
concern
they're
where
offering here.
Congress was very
I
clear that
agree.
it
I
did
didn't
not
agree with
want
that
to
decision.
include a
But it's
durational
not
limit.
the same argument being
Congress
made.
included a durational limit in Section 5 of the Voting Rights Act.
North Carolina
It
filed a
created
shit
mechanism for
argument.
reauthorization.
Or, well,
It decidedly
the people
did not do
opposing
that in
it
Section
did.
2.
I
issue,
hate to be
as
that
you know,
person, but
is
that was
this
what it
court's
was.
cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very
for you,
important
Derek.
distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, this case has affirmed Title VII.
So this is
It
an
has
interesting
affirmed Section
dichotomy here
1982,
because this is
the
something
Family
this court is
Medical
fond
Leave
of.
Act. And also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts.
It's not a
That
deliberate
particular
use of
aspect,
race.
I'm
It's
guessing,
ensuring that
I'm
people
asking,
are properly
what you think the
represented
time limit
within
on
their
that should be, or there
qualified
really shouldn't be a
criteria.
time limit. I think you might be saying
I
there
think
shouldn't
this
be
is
a time limit
Kavanaugh.
unless
It sounds
Congress
like his fucking
chooses
voice.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because?
Can I ask?
Is that?
I just wanted to follow up on Justice Kavanaugh's
Barrett.
question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming
Assuming that it
my
does.
question is,
Yeah,
Sure,
I was-
assuming that it does. As you know, in
Assuming
Bernie, this
is a
court held up the Voting Rights
big
Act as the
assumption.
paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional
That's
in order
accurate.
to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting
So,
the
Ms. Nelson,
1982
I guess I
amendments.
wonder if it would be helpful,
Jackson.
at least as I'm thinking about it, because I think this is a very important question. To understand, I think
Thank
that
you
you're
for coming
saying
in.
that
If you can just
Section
like
2
and
is
all the-
not a
the
remedy
things.
in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist. And those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
So that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less and less as we see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean,
cannot make the
it's a pretty significant showing to establish
Yes.
that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting.
She's going to go over jingles again real quick. Section 2, Part B. in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. That's where a big part of this argument is coming from.
Remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just,
No.
yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that prohibition of race discrimination on voting and does not require a time limit.
Thank you.
With the time I have remaining, I'd like to mention that there are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence of it, or the declining ability to show a Section 2 case, is because of the success of Section 2 over the past 4 decades. And we would be
this is a
reckless if
high
we
bar
determine
that they
Section
have
2
to
somehow
meet
is
to
no
prove.
longer
That's why
needed,
not all
simply
cases
because
prevail,
it has been
especially
so
when it comes to this.
in rooting out racial discrimination in voting. There's also, as I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Callais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use one of the many alternatives that are available that meet Section 2 and also comply with the Constitution. The liability finding in Robinson is undisturbed, and it must be remedied. If SB 8 is the inappropriate remedy, there are many other options for this court to pursue.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Yeah, let me pick up with where you left off, which related to the illustrative map in the Robinson case. And let me go back once again to what we said, what the court said in Milligan. The minority group, this is the first Gingell's precondition, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question in the illustrative map, the second majority minority district in the illustrative map, was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact. They met every traditional redistricting criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process.
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Just knocking stuff around.
It was a very serious.
Yes, it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the black population within the district in question in the illustrative map was geographically compact.
Nelson.
You have people from a rural area in the northwest part of the state, and you have people from an urban area many miles away, combined in a district.
That kind of
just for the
sounds like
purpose of
Gorsuch.
getting over the 50% BVAP.
So, Justice Alito, you might be referring to
Alito,
SB
sorry.
8 as opposed to the illustrative maps.
No,
I
I'm
get
referring
those
to the
two mixed
illustrative
up
map,
voice-wise.
Although the same may be said about SB 8, but I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection that what the district court did and what the Fifth Circuit did on appeal.
Thank you so much,
was
everybody
not
coming
to
in.
apply
If you
the
can
correct
like and
standard
share and do
under
all this
Milligan.
stuff.
Thank you.
Justice Sotomayor?
Counsel.
Yeah, she's very consistent and her
that-
arguments are good.
States maps
They always
showing
interrupt.
people
It's
in
not new.
districts
This
from
is just
the
how the
far
Supreme
north
Court works.
all the way down
This is
and
Sotomayor.
across the state.
That's correct.
The map that it put into effect. So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
All right. Now, you have not addressed the issues of the unconstitutionality, which is what this re-argument was about.
That part.
Justice Barrett mentioned congruence and proportionality. Others have suggested that our Harvard case
Yeah, they don't
is
care,
appropriate.
Lawless. They don't
One,
care at all.
Louisiana has said that the use of race in any way violates the Equal Protection Clause. Would you give us a couple of lines on why those, assuming, as the chief did,
That doesn't make them an
Mulligan and all of
illegitimate
our
court.
cases and precedents support you?
Sure.
The others are
I
now
know that's
saying,
easy to think that way, but it doesn't make it
your
illegitimate.
adversaries are saying, even if it does, we should still declare this unconstitutional.
No, it doesn't.
I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is in fact working more in our favor, we believe, than supporting our opponents. And there are many distinctions
Students for fair
between this
admissions
case and the
versus
SFFA
Harvard.
case. For example,
It's the
Section 2
affirmative action
is a decidedly
case.
remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fullalove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan, which is controlling here, is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term, in the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination.
Specified.
And the Section 2
That's why these
test
are hard criteria to meet.
gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns
They're gonna
of
love that
getting at
part of
all
the
discrimination in our electoral processes, but also
The
being mindful of
specificity
a
of
potential
Congress
allegation
is something
of
that the court has
racism
focused
against
on.
states
What
and
did the
other
law,
state
statute,
actors.
whatever
And so
specify?
Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions,
Correct.
including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of race is permissible
back to
in remedying
Thurgood
discrimination.
Justice Kagan?
Ms. Nelson, were Section 2 to cease to operate in the way that you just described to prevent vote dilution in districting, what could happen? What would the results on the ground be?
I think the results would be pretty catastrophic. If we take Louisiana as one example, every congressional member who is Black was elected from a
So
VRA
what you're hearing right
opportunity
now
district.
is
We only
outcome
have the
driven. When
diversity
we
that
talk
see
about
across the
activist
South, for
judges,
example,
I know that
because
can
of
be
litigation
one way,
that forced the creation
no matter where you're
of
at.
opportunity districts under the Voting Rights Act.
We talk about
Every
activist
justice
judges, they
in
focus on
Louisiana
outcomes
has
versus
been
what does the
elected
letter of the
through
law
a VRA
apply.
opportunity district, and
While I
nearly all
appreciate her
legislative
question
representatives
here,
have been
it's
elected on those same districts. So
with the
Louisiana
6
alone
justices
is an
being
example
conservative,
of how
originalist,
important it is to have
textualist, this is
Section
not
2
going
continue
to
be enforced to create
influence
these
the outcome of
opportunities.
these
We
votes.
also know that after majority minority districts have been created, they often no longer
Thanks, Gabriel.
need the same population to continue to provide an equally open electoral process for minority voters. So it is an intervention that has been crucial to diversifying leadership and providing an ability of minority voters to have an equal opportunity to participate in the process. But it also isn't a permanent remedy. It corrects itself over time, and it's only triggered when those extreme conditions exist.
That
Thank you.
part.
Justice Gorsuch?
Oh,
When it gets to the remedy side,
let's see.
do you think a plaintiff in a Section 2 case has to come up with a map where race isn't the predominant factor in the map, or is it okay for a federal court to use a map on the remedial side that intentionally discriminates on the basis of race?
You do not have to use race to create the remedy in a map, and I think that
Well, I'm asking whether one can. Sometimes you don't have to.
Yes.
I understand that. I'm
If
asking, is it acceptable
racial
under
cracking
Section 2
and
as you
packing
understand
is
it,
the
given our
problem,
precedents,
addressing
for a
it
court to
is the
intentionally
only
discriminate on a
remedied
remedial map
outcome.
on the basis of race?
Not in those words, not for a court to intentionally discriminate, but I think it depends. There may be a circumstance where the only possible remedy is the limited use of race. I will say that I think those circumstances are rare, and
Yes.
the permissibility of race is constrained by strict scrutiny. This court has a very clear precedent around ensuring that race does not motivate the line drawer in a way that requires a map to be drawn that isn't narrowly tailored, that uses race for race's sake. There are already constraints between Jingles and Shaw that keep the use of race within constitutional bounds.
I
That
understand
part.
that, but one argument is often, well, once you've found a Section 2 violation, you've got a compelling interest to go ahead and discriminate on the basis of race in your remedial map. And I'm just wondering, do you endorse that view or do you reject that view?
I don't endorse the concept of discriminating on the basis of race if discrimination has been established under Section 2 and a state determines that it needs a very precise incision of race in order to remedy that Section 2 violation, then Section 2 and
Yes.
this court's precedent supports that.
So
The
a federal
VRA.
district court can sometimes to remedy a Section 2
Well,
violation.
not a federal district court. I'm sorry. I'm glad you emphasized
Well,
that.
if I might just finish the question.
Yes.
Sometimes federal district courts order maps, and you're saying sometimes acceptable for a federal district court to order a map that intentionally discriminates on the basis of race.
I disagree with that formulation. So first and foremost,
They're
states
trying to talk it
and
back to,
plaintiffs,
like,
as they put forth illustrative maps,
oh,
cannot
well,
put forth maps
your
that
discrimination
discriminate
could be
and
other
that use race in an excessive fashion.
I think that
the
was
only
Alito. I'm
actor
not
that
super
has
fond of
broader
him.
leeway are states, because we give states breathing room. We give states wide latitude in order to balance their political interests and concerns.
So federal district courts can't discriminate on the basis of race in remedies, but states can?
Federal district courts can only order maps that are constitutional. And again, the constitutional boundaries are between Jingles and Shaw,
I
which
understand that.
sometimes
You said
permits
states
race.
have more breathing room, so do they have the breathing room to intentionally discriminate on the basis of race? when
They
brought-
don't have breathing room to intentionally discriminate on the basis of race.
Here's the thing. Here's the bottom line here to this fucking argument. I swear to God, it drives me crazy. Either make sure that states have to order, use third-party, nonpartisan things to, draw their maps. And I know they can't do that, but fucking, it drives me insane. Because they're trying to, make a dichotomy, or make a split between, federal and state and da-da. It doesn't fucking matter.
And you mentioned strict scrutiny as well, correct?
Correct.
But part of scrutiny, again, is the temporal limit that's been part of strict scrutiny for a long time. And I think your answers earlier to that, to me, and when you were talking with Justice Jackson, were, well, Congress, defer to Congress. But when we're applying the Equal Protection Clause, or as Justice Barrett said, the 15th Amendment, congruent and proportionality, or 14th Amendment, deferring to Congress is, I think, not what we're supposed to do. So what if we're not just deferring to Congress, Is there anything you can point us to that would not allow it to extend forever? The intentional use of race, which you acknowledge in response to Justice Gorsuch.
Sure. Well, we maintain that there does not need to be a durational limit, but there is some guidance that this court could
Third-party
consider.
companies
So, for example,
not letting
in Grutter,
states
the
draw their
court,
own
Justice
maps.
O'Connor
That's
suggested
really
that
the only
affirmative
fix to
action
this.
did not need to endure beyond another 25 years. She forecast that another generation might need affirmative action, and ultimately this court thought otherwise in SFFA. So that sort of runway, that advance notice, that expression of an ability for Congress to intervene if it disagrees with the court or decides it wants to remedy on
Agreed,
its own.
Marco.
That
That's a
is
great
the
question.
type of guidance I
Why
think
don't
this
we do
court should
that?
consider if it feels that it must.
Yeah,
pursue a
California,
durational
Minnesota,
limit
several
on,
states have
on
third
Section 2, and
parties
again, we
that
don't
do
believe
their
that's
maps.
necessary.
But
Justice
unfortunately,
Kennedy in,
Gavin Newsom
1994 in
is
Johnson
wanting to
versus
redraw them
DeGrande,
now,
he
so I
said a
don't know
couple
what that
things I
means.
just wanna get your
They used to just
reaction
use
to. He
third
said the
parties
sorting
to
of
draw
persons with an
reasonable
intent to divide
proportional
by reason of
districts.
race raises the most serious constitutional questions. And he added that explicit race-based districting embarks us on a most dangerous course. It is necessary to bear in mind that redistricting must comply with the overriding demands of the Equal Protection Clause. Do you take issue with what he said there?
No, what I think is missing from the understanding of Section 2 is the work that it has done to advance the goal of ridding our electoral process of race. It brings racial groups together, and as I mentioned earlier, many of the VRA opportunity districts ultimately convert to non-majority minority districts. Not all VRA opportunity districts are majority minority districts. And in fact, we see greater racial harmony and less racially polarized voting as a result of Section 2 districts. So Section 2 is addressing a pre-existing problem. It is not producing it. And in fact, it reduces
I'll show y'all
it more
my map
broadly
for
across
Texas.
society.
Thank you.
Justice Barrett?
So we've assumed, without deciding, this is picking up on Justice Gorsuch's questions, that complying with Section 2 is a compelling interest for purposes of the 14th Amendment. Correct. And now this is kind of picking up on some of Justice Alito and Justice Thomas's questions earlier. How are we to think about that when we're thinking about the Robinson litigation? Because it was a preliminary injunction, and Louisiana, of course, argued there that no, it wasn't a violation of Section 2 to have those maps. So I guess, how do we judge the compelling interest in avoiding a violation of Section 2 if the state doesn't really think it violates Section 2 and it hasn't been finally adjudicated yet? How do we approach assuming that compliance with Section 2 is a compelling interest? How do we think about that in a context like Robinson?
So states can, for good reason, draw a map that addresses Section 2 prophylactically. Here we have a finding from a district court based on a robust evidentiary record that we were likely to succeed on our Section 2
This is Harris
claim.
County,
This
Texas.
is not the first case. There are many
That's
cases
a district.
that have provided the basis for
What the fuck?
an opportunity
No
map to be
normal
drawn
computer
just on a
program
preliminary
is drawing a
injunction
district that
motion.
way,
And
period.
again, that
This is partisan.
that finding by
Like,
the
these are
lower
partisan
court was
drawings.
affirmed by two
That's not
federal
normal.
panels of the Fifth Circuit, and this court had an opportunity to revisit the Robinson litigation and did not.
But what if, district courts sometimes make errors of law, right? So what if the
do.
district court, I guess I'm trying to figure out how much weight then the district court's finding has in comprising that compelling interest in avoiding the Section 2 violation. Do you see what I mean? Like, what if
I
the
think
district
Fifth
court was
Circuit
just wrong, and what if
reaffirmed.
the state thinks that the district court was wrong?
Well, the state has already conceded that it.
Okay, no.
The state already conceded that it should comply with the Robinson decision.
Right. It got complicated here because of all of the other litigation, but why don't you just strip out what happened and answer the question, like, at the time Robinson was decided, if Louisiana thought that the Robinson court was wrong, that the district court was wrong,
But why?
but it wanted to avoid the court imposed map, wanted the opportunity to draw its own map, Justice Kavanaugh's been asking you what role race can play without running afoul of the Equal Protection Clause. And the state would have to say at that point, well, we're weighting race heavily because we have a compelling interest in avoiding a Section 2 violation. And the state's position might be, we don't actually really think that we violated Section 2, but we have a litigation risk. We know that if we don't draw this other map, the court may impose one. On that understanding, on those facts, not concessions and whatever is made, is that then a legitimate, compelling state interest when there is the possibility and the state in fact thinks that the district court was wrong?
It is still a compelling governmental interest. The state can do what it did here, which is to appeal to the Fifth Circuit, and the Fifth Circuit considered the same evidence and unanimously found that the Robinson court was correct. Yet another
Holy
Fifth Circuit
shit.
panel also
That's what
affirmed
I was
that decision.
saying.
Justice Jackson?
So in essence, are you saying in response to Justice Barrett that it's a compelling...
And to be clear, if nobody is aware of this, there are a few other circuits that are very conservative. The 8th Circuit, also very conservative. But the 5th Circuit is considered one of the most conservative appeal districts in existence. Like, I'm not even shitting y'all. The 5th Circuit, you put up 5th versus 9th Circuit. The 9th Circuit, will affirm anything coming out of California. The 5th Circuit will confirm anything coming out of the South. I want to be so incredibly clear about how conservative the 5th Circuit is. And the 5th Circuit reheard the case from the district court that Barrett was just asking about and said, yeah, no, you were kind of racial gerrymander. You fucked up. You need to do something about it. So just so we're clear. I'm going to go to the bathroom. Y'all watch up
And
your
that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing. And the Robinson court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson court's decision is before us right now. Because what I understood is that as a result of the Robinson court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson court has identified. And we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Callais case to support that.
Thank you.
Thank you, counsel. Mr. Aguinaga?
Thank you, Mr. Chief Justice, and may it please the court. Race-based redistricting is fundamentally contrary to our Constitution. It requires striking enough members of the majority race to sufficiently diminish their voting strength.
Solicitor General of Louisiana.
And it requires drawing in enough members of a minority race to sufficiently augment their voting strength. Embedded within these express targets are racial stereotypes that this court has long criticized. They assume, for example, that a black voter, simply because he is black, must think like other black voters, share the same interests, and prefer the same political candidates. And this stereotyping system has no logical endpoint. We are 40 years removed from jingles, and yet, according to my friends on the other side, nothing has changed in the voting and housing.
To be clear,
patterns in
Louisiana originally signed on with this on the
redistricting.
These
problems are part of why we never wanted to be here in the first place. They have placed states in impossible situations where the only sure demand is more racial discrimination for more decades. But I think if anything is clear in this court's dedication to eliminating all racial discrimination, it is that the Constitution does not tolerate this system of government-mandated racial balancing. I welcome the court's questions.
Why did the state of Louisiana switch sides since our last argument?
Your Honor, we told
That
the
part,
court at pages
that
1 and
fucking
2 of our
part.
original opening brief in this case that our predicament in this case presents as good a reason as any for the
Clarence
court to
Thomas,
reevaluate
you can
its
hate
voting
him,
precedents.
but sometimes
We
he
told the court at page
comes in hot
18
with
of
the
our original
questions.
reply
I
brief that we
fucking am
thought
here
this
for
would be
it.
a different case if the court thought
I don't
it
always
was
agree with his
worth
outcomes, but he
revisiting
does
the
not give
longstanding
a
assumption that
flying
compliance
fuck.
with
Like,
Section
he will
2
just
is a
say
compelling
it.
interest. Your Honor, we thought all along, and in my colloquy with Justice Kavanaugh back in March, we discussed our long-standing position in our state legislative map litigation, where we've taken the position that Section 2, insofar as it requires race-based redistricting, is unconstitutional.
Bullshit.
This court's re-argument QP
Bullshit.
squarely tees up that question, and so our duty of candor requires us to give the court our honest answer to that question.
General, the race-based redistricting that you're now
They're going
objecting
to bring up the
is redistricting
SFFA,
designed to
the
remedy
affirmative
specific
action one, to
identified,
defend that this doesn't
proved
fall under equal protection under the law because
violation of
blah, blah,
law.
blah. Watch.
more a specific identified proved racial discrimination by the state. That's the way in which the race-based districting is coming in. It's coming in as a remedy for specific proved discrimination on the state's part. How could that possibly fall subject to the categorical rule that you're suggesting?
Your Honor, I respectfully but firmly resist the premise that this comes to the court on a finding of specific discrimination by the state. I think if anything is clear about how Jingles plays out on the ground, it is that once you run the three preconditions and get to the totality of the circumstances, it's anyone's guess what the alleged violation is. I mean, I think Justice Thomas's call.
General, I mean, what Jingles does, and
And just to be clear here, he is the same person that argued the opposite position last year. Just so we're clear, he's the same fucking guy.
the idea that this is like 50 years later, this is not a kind of Shelby County thing.
No.
Where one could say that Congress had acted and 50 years later, the conditions on the ground might have changed and there would be no way to respond to that change. Because what Jingles does and what these Section 2 suits do is they ask about current conditions, and they ask whether those current conditions show vote dilution, which is violative of Section 2. So they say,
Holy
is there
shit.
racial segregation, racial residential segregation now? Is there racially polarized voting now? And when the state fails with respect to those issues, when those conditions obtain now, what our precedents say, and what you're asking us now to change, what our precedents say is that when those things operate currently, right as of now, and are
Imagine
proved in the
having
courtroom,
argued against
that,
your exact position,
that still
coming back to the
there
court
can't
and
be a
being like,
race-based remedy.
you should reconsider
That's correct, Justice Kagan, and I think
every
the two
precedent
trends
you
that my
have,
friends on the other
because
side
fuck
point
this
to,
shit
the
now.
rates of
It's so
ra- of
fucking
residential
embarrassing.
segregation
Like,
and the
it
rates for
couldn't have
racially
fucking been
polarized
me.
voting are what allow them to
I
get
would have been
past
like,
the
I
Jingles
fucking
preconditions.
quit.
They told you at page 33 of their yellow brief that those things are worse today in Louisiana than they were in the 1980s, and this court said at page 228 in Northwest Austin that those sorts of factors are not evidence of intentional discrimination. That's not intentional discrimination,
It's
Justice
not
Kagan.
intentional
He
discrimination.
had to pull
because
out page
Section 2
228.
is not about intentional
That was
discrimination.
a dissenting
Section
opinion,
2
likely.
is about effects discrimination. It's about Congress saying, and specifically in response to a decision of this court, that intentional discrimination and the values behind that prohibition can only be vindicated if Section 2, under Section 2, the state shows that the effects are not discriminatory. And, Congress put this court in its place when it said
Impact,
that. And so what
intent.
Section 2 does
Intent,
is to say where the
impact.
effects are discriminatory.
You have to consider
such
that when you're
people
deciding these
are
cases.
not having the same.
You can have a fucked up map,
African-Americans
but
here
if you can't
are
prove
not
that
being
it
given
dilutes your
the same
vote,
voting
you're fucked.
opportunities as white people are, then a remedy is appropriate. That remedy doesn't have to be race-based, but sometimes it is race-based.
Yeah, go to
in
the
order
fucking Supreme Court
to
website.
correct
Get out of here, whiny.
the racially discriminating racially discriminatory situation that exists in the state right now.
And Justice Kagan, if Congress had attempted in 1982 to make a record of intentional discrimination in districting, and today, if there were a record of intentional discrimination in districting, then there might be a congruence and proportionality argument to sustain race-based redistricting as a remedy. But I think something
You
that
already
don't
had
see
to
in the
redraw the
congressional record in
map.
the
You
1980s
couldn't
and something
prove
that
it was
doesn't exist
discriminatory
today
because
is that
they said, no,
justification.
fuck you,
And
this
that's
is
why I think
discriminatory.
That's because they weren't dealing with the history of it, they're dealing with the current situation.
This is oral
And
arguments
Ingalls is,
for
as
Orlando.
Justice Kagan pointed out, what's happening today, and are there lingering
Thank you,
effects of
Buns.
the past? The one thing I look at is Alabama's maps for the last 30 years.
Thank you to everybody coming
The
in.
map
I love y'all
that-
so
that
much.
The Robinson Court found cracked and packed voters was a map that's been in effect almost the entire history of Alabama. That map was put in effect because of discrimination. So it's going to have a lingering effect. They wanted to pack white voters. They've been doing that. And they wanted to crack black voters as much as they could, and they've done that. And it's only Section 2 and Section 5 that kept them creating one majority district. But using race is a part of redistricting always. We've said that the only actionable part that's intentional if it predominates. But race is always a part of these decisions.
Just to go over this
And my
real quick,
colleagues are trying to
cracking and
tease it
packing,
out
because this
in
is coming up a lot.
intellectual way
Cracking
that
is where
doesn't
you
deal
split
with the
minority
fact
voters.
that
You
race is used
crack
to
the
help
district. Packing is where you
Legislators might try to
dilute their
keep an
vote by
ethnic community in
placing
one
them
district. They might
in
consider
to
it to get a
districts
sense of
where
which district to
the
draw an
majority
incumbent
will
into.
overwhelm their
They might
vote.
review it to
That's what
predict
cracking
kind
and
of
packing is
issues
in a
district
very
voter might
simplistic
be
term.
particularly interested in. They might use it to inform partisan goals. We permit all of that. What you're saying to us, if you use it to remedy past lingering discrimination, intentional discrimination, then you can't use it. You can use it to help yourself achieve goals that reduce a particular group's electoral participation. But you can't use it to remedy that situation. That's what you want us
America
to
first, bro. I'm
Justice
trying to
Sotomayor, my
explain
humble
this at
point
like
is that the
base
government
level,
has no
not
business
something super
telling
specific.
citizens in which districts they may live or what voting
But
power
it's
they
not
may
doing
actually.
that, counsel. The 6 plaintiffs in this case are white plaintiffs who live in a district with black voters. So no one's keeping
I
them
agree,
out
that
of
can happen,
district.
but that
No
wasn't what I
one's
was
stopping
trying to
them
cover.
from
That's in the
participating
context
the
of what we're
voting
doing
process.
here, this
No
is
one
what they're talking
stopping
about when it
them
comes to
from
cracking
trying
and
to run
packing.
candidates or support candidates that reflect their views. But this state is stopping black voters from doing that in many districts because it's packing them into areas that whites overwhelm them.
There it is.
I don't understand.
No, you're good, you're
So
good,
Justice
sorry.
Sotomayor, let's look at the facts in
If
this
you
case.
can use
My-
race in some ways that are positive, why can't you use it to remedy something in some ways?
Your Honor, my friends on the other side walked into the Middle District of Louisiana. May I finish very briefly?
Yes.
Walked into the Middle District of Louisiana and demanded a majority black district. What's the purpose of that kind of district? The avowed purpose of drawing a majority black district is to diminish the voting strength of
doing
some
good
racial
here.
groups and augment the voting strength of others.
Because you're looking at
Thank you, Councilman
population.
Thomas.
You're looking at population and
What
representation.
role did Robinson play in the development of SB 8?
Justice Thomas, Robinson is the only reason SB 8 exists. We fought tooth and nail in the Robinson litigation itself in telling the courts that we did not think the Constitution permitted us to draw a second majority black district. As you know, under protest, we drew SB 8 because the threat was that the federal courts were going to do it if we didn't.
He does
And that's-
sound
I mean,
pissy.
I think that's the best way to
That's
conceive of why
good.
SB 8
I
exists.
was thinking,
We
I
would
was like,
never
he
pass
sounds
SB 8 in the
mad.
first instance without Robinson, Justice Thomas.
What were the findings in Robinson?
The finding by the Middle District in Robinson was that the plaintiffs in this case were likely to show a violation of Section.
But it also went before the Fifth Circuit, who reaffirmed that. And he does not want to mention that because that's not a reality they want to confront.
Our legislature saw that. We understood the marching order, and that's why you see SB 8 as it exists today.
Just briefly, what were the findings that led to that conclusion?
Well, Your Honor, running through the preconditions and the totality of the circumstances, I mean, I think the totality of the circumstances did most of the work for the Middle District in Robinson. Senate Factor 1, the official history of past discrimination. Justice Thomas, we can never outrun the bad era of poll taxes, of grandfather clauses.
He's probably mad he had to flip his position. He argued this last year, but argued
the Middle District in Robinson
with
focused on
the NAACP on it.
in the 1930s, 40s,
Fucking
50s, 60s.
so embarrassing.
And,
it could not
add
have
all
been
that
me.
together, and at the end you have a vote dilution finding that I don't think is clearly articulable in the way that SFFA requires a finding of
I mean the
discrimination
flip-flop,
to be
not
specified.
arguing for the NAACP. I'm
Mrs. Alito?
sorry if that came
Can
across
I
wrong.
clear up a couple of factual points that have been brought out by the questioning? Your HB1, enacted in 2022, followed to a large extent the map that you had for the prior decade. Isn't that right?
That's exactly right,
It was
Justice.
suggested that that prior map was discriminatory. What was the origin of that?
Attorney
prior?
generals
Do I
are
remember
a
correctly that
wild
it was
sort.
pre-cleared by the Justice Department?
Twice. That's correct, Justice Alito.
So it wasn't, there's no finding that that map was based on discrimination, and that by following that map, you were perpetuating prior discrimination.
No, Justice Alito, and I think that's why I firmly have to resist any suggestion that the Louisiana State Legislature is out here targeting minority voters and trying to abridge the right to vote. That is just completely unfounded.
As to the suggestion that there was a proven
Don't play with me.
violation in the Robinson litigation.
Louisiana
that
is
was a
heavily
preliminary
Republican,
injunction,
if
right?
people are unaware of
That's
that.
correct, Justice Alito.
There
When
wasn't
we
a
think of
finding that there was a
Louisiana, we think
violation,
of like the
at
big
most
cities,
finding
New Orleans.
that there was
No,
likely to be in violation.
heavily
shown.
Republican.
And is it not correct, for the reasons that I brought out in my questioning of Ms. Nelson, that what the district court did there was not to ask whether the minority group was sufficiently compact, but whether the district itself was sufficiently compact?
That's exactly right, Justice Alito. And if you look at the black population in Louisiana, I mean, it is all over
Notice
the place.
how
You can
he's
identify
name
pockets
addressing
of black
Alito.
voters,
He
but
knows
they
this
are
is a key
dispersed
vote
across
for
the state.
him.
There's no way you can conceive of that population as compact.
Thank you.
Justice Sotomayor?
I may be
Well, they're
remembering
pulling the same
record wrong
bullshit
on this,
Texas
'cause
is
it was a while
pulling.
back.
They're they're in court
If I
right now on their
recall,
maps.
The district court looked at the three main parishes that make up District 6 now, and looked at it and said, they have a commonality of history. Many of its residents go from where they live near the Baton Rouge area to work or go to school, and they go back to their communities. They have long
I live in
family
Texas
ties
too,
between
so
the
I feel ya.
communities and among the communities. There may be a difference.
But they
in
opened up 10
education
districts to be
and,
flipped,
and
Ms.
some
Ingram.
income
Actually, by my count, it was
differences.
about 12.
But that's true of
that's
all the
neither here nor
districts
there.
in Louisiana.
So they kind of
You've
fucked
got the
themselves
districts
on
that are
that.
protecting
Just
incumbents,
FYI.
where in the north, there's less money than in other areas. So those differences are not meaningful. But I thought the district court did a very careful analysis.
Yeah, Parkers. One day I'll
of the
go through it on
commonality of
Discord with
interest of
everybody.
those of
I'll
that
have my
black community.
PowerPoint.
You may disagree with its finding, but it did do that analysis.
Your Honor, no doubt the Middle District purported to run through the Jingles analysis, and it said, it will be the
You're
unusual.
disagreeing with it, but it did do that.
It did what this court's precedents allow lower courts to do. And Justice Sotomayor, my only point in response to that is to say, when the district court was asking about what the minority group does and thinks and prefers, it is exactly the sort of racial stereotyping that this court's precedents say is impermissible.
Counsel, with respect, the last time the SG was here before us on behalf of your state, they said that
It was
race
him.
did not predominate just with your creation of District 6.
It was him
Because what
arguing
you
the
were
last
trying
time.
to do, and why it's oddly shaped, was to protect incumbents. Are
This
you
is
walking
so
that back?
embarrassing.
Your Honor, our position in our supplemental briefing on racial predominance is as follows. If race is a non-negotiable in the drawing of a new district, we think that should
And
satisfy
thank you for
this court's
everybody coming
predominance
in. If you can just
analysis.
chop and like
And the
and do all the
argument
shit.
is-
But that's just it, which is, was it?
I wouldn't
What
have been.
really was
I would have been
non-negotiable
like, you
for
were here a
was
year ago
nonpartisanship.
saying that this shit wasn't true.
And you could have picked.
Probably why
one of
I'm not
other
on the
maps,
Supreme Court, though.
illustrative
Just to be
map.
clear.
You didn't have to, but you drew this because of your partisan needs more than because of race.
We drew it for partisan reasons, Justice Sotomayor. My point and the point we make at the end of our opening supplemental brief is to say, when this court's racial predominance questions ask about non-negotiability, it shouldn't matter if race is the one non-negotiable factor or it's one of 10 non-negotiable factors.
Well, but
In both
we always talk about what predominates and what.
For the love of God, if you can disenfranchise people by cracking and packing districts to dilute their vote based on their race, you cannot then turn around after you've argued that you did that and claim we don't do it. This is so fucking, I'm sorry, I'm getting a little worked up. I apologize. I'm gonna let it go.
That you've repeated each and every one of those arguments that we rejected. So I'll just run through a few of them. What they said was that the 15th Amendment permits Congress to legislate against only purposeful discrimination by the states. We rejected that. We said, no, Section 2, which is an effects-based test of vote dilution, is permitted under the 15th Amendment. There, in Milligan, the state said that the 15th Amendment doesn't authorize race-based redistricting as a remedy for vote dilution Section 2 violations. We said, no, that wasn't correct either. You just repeated it, but we rejected it. And they said that we should adopt an interpretation of Section 2, and I'm quoting here, that would revise and reformulate the Jingles threshold inquiry that has been the baseline of our Section 2 jurisprudence for several decades, and we rejected that as well. So each of the propositions that you're putting forward here, that Section 2 has to be limited in some way just to purposeful discrimination, that it doesn't authorize race-based redistricting as a remedy, and that we need to fundamentally overhaul the Jingles threshold inquiry, was rejected, I don't know, 3 years ago, 2 years ago, by a majority of this court.
Justice Kagan, the court has never addressed and rejected the two key parts of our argument here. The first is the court has long assumed, without deciding in cases like Cooper versus Harris, that compliance with Section 2 is in compelling interest. We're asking the court to finally decide that question and answer it no. The second question, the Allen court.
Well, but you're asking us based on arguments that have been specifically rejected by this court over many decades and 3 years ago.
Your Honor, this is an antecedent question that the court has routinely left open in its voting precedents, and that's why we're asking the court to address it here. If I could just answer the second question that the court has left open, in Allen, the court left open the question of whether a logical endpoint is identifiable in the race-based redistricting context. And our submission to the court is it's time to answer that question and answer no, because there is no logical endpoint to race-based redistricting under Section 2 as the court has construed it.
Oh, really?
Justice Gorsuch? Justice Kavanaugh?
Yeah. No, he's a
Let's get
total
your views
piece of
on
shit.
pages 25 and
If you
26
can waffle
of the
your argument
Solicitor
like
General
that,
of the United
you're a
States'
big
brief,
piece of crap. You have zero
where
principles.
they say this court should hold that the plaintiff's illustrative district cannot disregard the state's political objectives, and further say that Section 2 plaintiffs cannot claim a lack of equal openness or politics rather than race is the likely reason for the state's refusal to create a majority-minority district. You have thoughts about the Solicitor General's approach, and then in the course of answering that, do you see differences between your basic submissions and the federal government's submissions? I'm going to ask them that too.
So
I do, Justice Kavanaugh. I do
Buns,
think the top line response is we like the proposal.
it's
and we
not
don't.
our last
I think
hope.
we like it
Our
insofar
literal
as you know
last
from
hope
our
is
original
getting
briefing and our
Congress to
supplemental
do
briefing
their
that the thing
fucking
we want
job.
most as the state is clarity in this area of the law.
I'm
And so
fond
any
of the
remodeling
saying,
of jingles that brings about that clarity,
legislate,
of course,
don't
we're going to
litigate.
like. I think the reason we don't like it, there's a practical
They make
practical
this
reason and a
shit
doctrinal
really
reason.
broad,
I think the
and then
practical
we have
reason
to
with
go
the
into the
proposal
courts
is
to
that
solve
you're
it
probably
when
gonna
they
see a
can't
new
just
front of Section 2
fucking
litigation
do their
over
goddamn
what
job.
any new test means and how it
Drives
plays
me
out on the
insane.
ground. And so I think
I
the
mean,
upshot
yes,
is the courts are
constitutional
going to continue
questions,
to be
certainly,
inundated
there,
with Section
there's
2
gonna be
cases
stuff
under
that
this
comes
new
up, but a
test
lot
if
of
it
this could
exists.
be
So
solved if
as
they
a
just
practical
did
matter,
their
I don't know
job.
that we get much
What's
better.
the practical lack of clarity that you see? I guess I would have thought that solves a lot of the concerns that you've identified and that the amicus briefs that support your side have identified so far.
Yes, if I could answer that and then get to the quick doctrinal point.
Yes.
On the practical point, I do think
Not a
that you
clue.
start to see hints of this in the Robinson Appellant's yellow brief, the supplemental yellow brief, which is there's going to be a lot of disagreement in the lower courts about racial predominance. That is a critical trigger in a lot of this court's cases. And unless there's absolute clarity about how that analytical framework shakes out, then you're still going to see this onslaught of litigation that we see today in the Section 2 context. The doctrinal reason, Justice Kavanaugh, why we're not, it's like totally thrilled with the proposals. I think it's just a half solution to the constitutional problem, because at the end of the day, what the government's asking you to do is keep jingles in some form.
No,
and as
Steph,
we've laid
what
out in our
Congress
supplemental
shows
briefs,
over and over
jingles
again,
1, 2, and 3 are
in the face
expressly
of
built
doing
on the
something
sorts of
versus
racial
doing
stereotypes
nothing,
that the
they
court's
will
cases
choose
say are
nothing
impermissible
if it
under
means
the
they'll
Equal
get
Protection
reelected.
Clause. And so I think
Period.
that anytime, any test,
Or they'll
whether it's
choose
good or
something
bad,
really
as a practical matter,
performative.
that at the end of the day is asking the government to
And that's not
assign
just
voters to
Republicans, that's
different districts on
Democrats
the basis
too.
of their race,
If you think
and is
your
engaged in
reps work for
stereotypes about
you,
how members
you are
of a
living
race
in La La
simply by
Land.
virtue of
Your
their membership
reps
in that racial
exist
class
to be
think-
reelected.
I think that's a constitutional problem, and so that's why it's not wholly fulfilling.
I think the reason they say we haven't really addressed their proposal before in our jurisprudence, in part because before Rucho, states wouldn't articulate that objective explicitly, and therefore it's an open question. Do you agree with that?
I think as a practical matter, that's probably true, Your Honor. I mean, I think pre-Rucho, states were going to be very hesitant to venture out to say, overtly, like politically, like here's what we're doing. And so that is, I think, a great explanation of why the court's cases have treated the political versus racial divide as it does.
And just on common ground here, because I think it's always important in a case like this where there's disputes to identify what's common ground. Justice Jackson said the goal is equal opportunity for all Americans. I think we all agree on that completely.
Do you though?
And the goal, of course, is racial non-discrimination. But at the same time, given history and given Congress's action, the goal is making sure that there have been sufficient remedies for the history of discrimination in the United States, and we've seen that in the school desegregation context, in the college admissions context, and a variety of contexts. And then Ms. Nelson, I think, suggests...
The question that he's failing to ask, and the question that they all want to answer, but they keep beating around the bush, is just... how much discrimination is okay? How much can we discriminate? How much can we let you get away with before we have to do something about it? They have stare decisis on this. They have settled precedent on this. I don't even know why they didn't answer this last term, the first fucking time it was argued, but it is wild to me that the Solicitor General of Louisiana has now flipped his position, arguing on the other side, along with the non-white voters that are pissy and the Trump administration. I'm just saying.
Stereotyping is not permitted under the 14th Amendment. The warning bells have been sounding for decades, and I think that's a long enough notice for anybody involved, Your Honor.
In response to Justice Kagan, Ms. Nelson said that black representatives and justices in Louisiana have primarily, if not exclusively, been elected in minority opportunity districts. and that the results would be
This is still the
terrible.
Solicitor General of
you wanna respond to
Louisiana.
that?
Or not
Sure,
Solicitor
Your
General,
Honor.
sorry,
I
Attorney
think
General, I
There's been a lot
apologize.
of sky is falling rhetoric from the other side in this case. And I just want to give you like one political reality why I think that's a little overstated, which is remember that in a case,
Notice
let's use a
he's
state
so
like
calm
Louisiana,
here.
Republican legislature, if a Republican legislature wants to maximize its political seats, draw a 6-0 map, remember what has to happen with the hundreds of thousands of Democrat voters that currently exist in the majority Democrat districts, District 2 and District 6. They have to go somewhere, and that means that if the legislature wants to take the risk of maximizing, what they're doing is turning safe districts for high-profile political incumbents purple. And that, I think, is a very dangerous political risk. I
Texas
don't know what our
did that as
legislature
well
would do if the
when
court
they
rules in our favor.
drew this
But I'm just
last
saying
map.
that's one political
So
reality
they got fucked.
that makes me pause and say, I don't think the sky is going to fall.
Thank you.
Justice Barrett?
Just have a clarifying question to see how I'm thinking about this.
I want to see how he addresses her.
The arguments that are being made. Would you say that Section 2, insofar as it goes beyond just intentional discrimination, because as Justice Kagan said, Congress amended it when we said that before, is itself an exercise of the enforcement power? Judge, I'm going to assume here that Congress's enforcement power is necessary and the congruence and proportionality test applies to Section 2.
It does.
Do you agree with that conception? And I guess just to tell you where I'm coming from, I mean, it's one thing to say that the map itself is the remedy, but it might also be that the statute itself, insofar it goes beyond intentional discrimination, is the remedy.
Yes, that's fair.
Is that a way to think about it, or is that how the arguments are going?
I think that's right, Justice Barrett. I mean, I think the court's precedents assume that if a plaintiff in a Section 2 case can prove up the preconditions and the totality of the circumstances, the automatic remedy, at least in this case, is going to be a majority-minority district. And I think the court's precedents assume that that is statutorily mandated. Like that's just the natural the consequence of a violation
they're not
finding.
statutorily
So I do think it's built into the
mandated.
statute. Now, there was a lot of discussion earlier about whether we're attacking Section 2 itself, like
You are.
facially, and that's just not true.
Yes.
The re-argument QP in our briefing has been focused solely.
Their briefing is solely focused on saying, hey, if you're putting any racial consideration into this, you can't do it. No, that's not how the Voting Rights Act works.
Section 2 to remedy an alleged
So
violation.
you don't understand yourself to be arguing that any part of Section 2 is itself unconstitutional, but simply is the way that courts have been applying it.
You would
goes
have to
beyond.
make that
That's correct,
argument
Justice
for
Barrett.
his
I mean, this
challenge
court's
to
precedents
stick.
culminating in SFFA have said if the racial classification that a government's
Section
employing
2,
to allegedly
14th,
remedy a
and
violation
15th,
is
and
what's
how
at
they
issue,
cross
that's
over
the
and apply.
constitutional problem, and that's where we focused our briefing.
Thank you.
Justice Jackson?
So where in Section 2 does it mandate another minority
It
district?
doesn't.
I mean, my understanding, as I explored with Ms. Nelson, is that Section 2 is the mechanism by which we determine that equal electoral opportunity is not being provided for a certain minority group.
A violation of
Interpreted in
subsection is
Ingalls,
established
given
if
some
based on
flesh
the
to how one goes.
If based on the totality of circumstances, it is shown that the political process leading to nomination or election in the state or political subdivision are not equally open to participation of members, but of a class of citizens protected by subsection A, in that its members have less opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. The extent of which the members' protected class have been elected to office of the state or political subdivision is one circumstance that may be considered.
Remedy, as parties
That's
and the courts
literally
have
Section
understood
2.
Section 2 to operate, is almost always going to be
No,
race-based. That's why they went.
they're so tied up with race because that's the initial problem, right? That's that's the beginning. The beginning is the claim
That part!
that a person makes under Section 2 that because of their race, they are not being afforded equal electoral opportunity. It is a separate question as to how we go about remedying that and the extent to which we need to use race as a remedy. That's the question we're here on today, but the Section 2 issue is just what circumstances do we look at to determine whether this problem of unequal electoral opportunity on the basis of race is occurring.
Right, and a couple of responses to that, Justice Jackson.
Wait, so can I just ask you, why is that not a compelling state interest to identify areas in which that problem is occurring?
Your Honor, of course, as this court recognized in SFFA.
Notice how
states can
different
remedy
he
intentional-
No, I'm not
sounds
talking about the remedy. I'm talking about
between
the
talking to
identify.
Alito versus
All right,
talking
so
to her.
If I'm right, that section 2 is about identifying the problem and then requiring some remedy. I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is
That
another
part.
issue, right?
Your Honor, I think step
That
zero in
part.
all of these cases, it was certainly step 0 in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
This
I thought they came in and
motherfucker.
said we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's
black
not,
district.
because again, just trust me.
He
on this.
did not just
The
say that
second
shit.
electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong. You're fine.
They did
There
that
is
in
not
North
an electoral
Carolina not
opportunity
too long
denied to
ago.
Go away. In this
They said,
case,
"Fuck
the court
off.
said,
This
"I
isn't a good
see.
case."
I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
Right, and the problem, Justice Jackson.
What I was
that the
telling
Middle
you about
District
before
identified
is that the
was not
problem
intentional
versus the
discrimination.
remedy
And in
are
fact, I
two
think when I hear
completely
Intentional
different issues.
discrimination to remedy a problem like the one that I've identified.
Because if you're going to use race the way that the Robinson appellants want the court to use race in drawing a second majority minority district, you've got to have a compelling interest.
Thank you.
And
So
Thank you, Mr.
she
Chief
said,
Justice.
bitch, no.
Mr. Grime?
Brime is the person representing the non-African American challengers. That's specifically how it's noted in Scotus bottom. So the white folks.
Mr. Chief Justice, and may it please the court. The appellees should prevail here regardless of the grounds on which the
Eat
court
shit.
chooses to rely. In today's America, voters like the appellees are still being racially stereotyped to place them into single-member districts. If it was ever acceptable under our
She did
colorblind
just shut him up.
Constitution to do this, it was never intended to continue indefinitely. Section 2 effects findings alone can no longer justify the widespread stereotyping of American voters based on race in violation of the 14th and 15th Amendments.
Yes, this is the
It is
claim they're
time to
making,
reach
that
a
it
question
violates
this court
equal
has never
protection.
reached and hold that Section 2 alone is no compelling interest for racially gerrymandering citizens like the appellees today.
Oh, well, what
The
about
court should
majority
affirm
white
and direct the
districts
district court
that
to order
contain
a remedial map
Republicans? Do
in
they
time
have
for
the same
2026
feeling about
elections.
that?
I welcome any questions.
The last time we had this case, and in the materials that we have, there was quite a bit of discussion in the debate surrounding SB 8 that this district had to be drawn this way, the second district, because of the litigation earlier
Yes,
in the
Ms. Thomas.
Robinson case. What's your view of the role of Robinson in the development of SB 8?
Well, it has exactly one point of contact, which is the state has admitted that it felt that it had to draw a second majority-minority district because of Robinson.
They
to avoid
felt they
trial
had
in
to do
Robinson.
that. Were they
Did not wanna
ordered to
have a
do
trial,
that?
during the time it was going to be scheduled, and so they passed the second majority-minority district, and they race predominated in doing that.
When you say race predominated, what exactly do you mean by that?
He's asking
I
some
just
good
mean to
questions.
apply the standard from Cooper and
Well, I mean practically, how is it used in your mind, or in your thinking?
Well, basically the state went to the strongest remaining area of minority population, which was East Baton Rouge, and then they looked about the state for enough minority voters that was still contiguous to the main concentration in East Baton Rouge, and they went to the Northwest. And again, the goal that could not be compromised, which was the standard here, was that they had to draw a second majority minority district, and that made race predominate, both in the direction and in the details of how the lines were drawn.
Mr. Grime, you and the Solicitor General spoke about stereotyping and how there's no place for stereotyping. But I'm wondering what stereotyping has to do with any of this. The requirements of a Section 2 vote dilution claim are essentially that there's residential segregation by race. That's not stereotyping. That's just where people live. And that there is racial block voting. Essentially, that whites won't vote for a black candidate. That's not stereotyping either. That's just what the data shows about racially block voting. So I'm wondering how it is that stereotyping gets into this case at all.
Well, Your Honor, two points. First of all, stereotyping is the remedy that occurs when race predominates and is used to sort
that's a good
voters
point.
into one
It's
district or
okay
the
to
other.
draw
And the reason that's
a map
important is
for
to go back to
partisanship,
the second kind of predicate
to
your question.
disenfranchise voters
In a jingle
based on
showing,
their partisan
the
lean.
showing that's made
But
is
it's
not
not
that
okay
white voters or majority voters won't vote for
to
the
draw
minority candidate.
maps based
the only
on
showing
whatever
that's
else.
currently being made is correlation. And so what we're not seeing in cases today is a showing that we can separate out partisan politics, any partisan motivations that the majority or minority voters have. And so that case could come along, but that's not part of the required showing of jingles the way courts are applying it.
Well, I think that
Here's the overwhelming problem they have with it. And I realize, like, this is just a hard line. But for the majority of black people that do vote, they heavily vote Democrat. If you are in a Republican state, it is in your best interest to disenfranchise them, whether that be cracking and packing them with white voters who dilute their vote. And I'm not saying they should be doing this. I'm just saying the reality of this situation is what it is. We know overwhelmingly all the data shows us that they don't vote Republican, largely. In bigger swaths than almost any other group, Latino, white voters, et cetera, black people overwhelmingly vote Democratic. Republicans will try to disenfranchise that group. I apologize, but I wanted to add that in so people understand context here.
see what where stereotyping comes into that. It's just there's a there that African Americans can't elect candidates of their choice.
Well, the problem, though, is in the remedy. The problem is that when you are drawing your remedial district, which is the very first part of jingles, I mean, that may not be the final district you end up with, but just to reach, I'm covering your question and a question Justice Jackson asked.
Well,
the
maybe
very first thing the
these
plaintiff shows is here's the community that was
African-American
cracked or packed.
petitioners should
And
do
so
what
to
they tell
undo
us to
that,
do about abortion.
You have to look
and
at the
just
race
move.
of the voters all around that area.
Fucking move.
And you've got to make assumptions
You don't
about
like your
them
district?
based on
Move.
statistics, but you've got to make assumptions about what they think and how they vote based on their race. And you're drawing new districts based on that.
Yeah, I mean, this is the thing that we decided in Milligan, because what the state said in Milligan was that the plaintiffs could not use a map that was at all race-based themselves in order to show that there was a way out of
Doing the
this
same
kind
thing
of
in
vote
Ohio,
dilution,
Buns.
these kinds of vote dilution practices.
They're going through that right now.
And the court said, of course you can do something that is race-based, even though not race predominant, that we're not going to insist that you come in and ignore the factor of race when the only reason we're here is because race has played such an integral part in the voting process that people are being deprived of their voting rights because of race.
Well, Justice Kagan, the plurality in that section
Kagan nailed
of Milligan drew the line between race-conscious and race-predominant districting. Race-based appears, and maybe we need to define all of our terms. It appears in the decision, but But I think what is clear from that case is that the remedial maps can't allow race to predominate. I mean, the court said that the remedial map, the illustrative map, can't violate the court's redistricting decisions. And of course, there's the entire Shaw line.
I don't think that there's any dispute as to that point, but we're a long way from racial predominance to have the plaintiffs come in with a map that in order to remedy the race-based problem that exists, the violation of voting rights based on race, itself takes race into account.
Well,
that's what Milligan said 3 years ago.
The problem,
and that wasn't a stereotype issue, and it wasn't a kind of like we're based on past conditions issue. We're based on current conditions, which is that we just proved a violation of people's voting rights based on current conditions.
Stereotyping is always the main injury in a Shaw case. It's always the injury when race predominates.
But you're asking for changes to Section 2, which is not the Shaw case. That's the confusion.
That part.
I understood that the illustrative maps that the plaintiffs bring in the beginning of a Shaw case is part of their showing that we have a problem. They're illustrative. They're not what Louisiana picked in this case. They're not what the court requires. The court gives the state, once the violation is established, the opportunity to draw it.
Okay, so I'll give y'all a little bit of a specific here because this douche nozzle is the worst. This is just a little synopsis. This happened in 2022. A different federal district court ruled that Louisiana's first congressional map after the 2020 census likely violated Section 2 of the Voting Rights Act because it contained only one majority black district, despite black residents making up nearly 1/3 of the state's populations. If you have 6 districts with black people making up 1/3 of these 6 districts, why is there only one majority black district would be the question. Now, they didn't tell him you have to redraw a black district. That was not what they said. They just said, hey, you may have a problem here, just for clarity.
That if you demonstrate that the state intentionally is causing this to happen to you.
Well, that's not current doctrine under Jingles, but the problem is
that your argument? Is that what you're saying we have to do?
Our argument is that if you're going to allow a race-based remedy,
basically,
it must
Tony,
be in response to
there's a lot of cases where I can be really impartial. This one is just absolute ridiculous.
Or problem with your vote, the kinds of things that Congress cared about and that the Constitution requires, you don't get a remedy unless this was intentional on the part of the state with respect to you.
Which is a constitutional vote dilution claim, which people always can be bringing.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
So I'm assuming that the ban on poll taxes,
thank
literacy,
you for the follows, likes, and all this stuff.
Poll taxes, because those have been eliminated by the 26th Amendment. But the literacy ban that we have will sunset too?
Those are not those remedies don't require racial stereotyping.
Well, they do, because to prove them, you have to prove that it affects the races. I mean, I just don't understand the
holy shit, Sotomayor with the
concept
banger.
In the Jingles factors. The Jingles factors is looking at whether these people have, their vote is being diluted, or
so he's trying to make the claim that race should be completely ignored and blah blah blah, and they're like, yeah, but in order to make this claim, you have to factor in race to make the claim you even have.
You can use race. Now, you want to add the qualifier, it has to be intentional, but I don't see the 15th Amendment being limited that way. The words of the 15th Amendment are that Congress can stop any practice that dilutes voting. Practice is an act that has an effect. It didn't say intentional dilution of voting. The amendment itself talks about a practice.
Your Honor, this court has never held that the 15th Amendment addresses anything other than intentional
No, it
discrimination.
does. That's
Okay, the 15th Amendment specifically prevents the government from denying any male citizen the right to vote based on race, color, previous condition of servitude. So, they're making the argument
just
that
not
white
true.
people are
We
being
just
denied
Milligan,
like
we
this
said,
right to vote. And I'm just going to
slew
call
of
them white
cases.
people, but in their
Congress
descriptor,
itself
it's
said, we're not
non-African
using
American
intent,
people.
we're using effects. And we said
Like, bro, that's
okay,
just the
that's
breaks.
within their power
Sometimes you get
as
in a shit
specified in the
district
15th
or a
Amendment.
district you don't want to be
But
in,
Your Honor,
fucking
you
move.
can only catch the effects.
It's not
as
a racial
part of an
thing.
that's just the enforcement
hate
power
this.
at that point.
That's their
So
claim,
you're
is this
using the
isn't racial,
enforcement
but they're
power
claiming
based
that
on
this is
showing.
basically racial discrimination.
The
It's fucking
case
wild.
law going back to
At least this
Katzenbach
particular
and-
lawyer who's representing the
sorry.
petitioners.
Yes.
Sorry.
Justice Sotomayor.
Well, I'll stop and you pick up.
Justice Kagan.
Sorry. You're all
No,
done.
you're not done.
It's like, oh shit.
What we've said, and this goes back 14 years, and it was said again in Milligan, is that even if the constitutional prohibition is one on purposeful discrimination, Congress can enforce that prohibition under section 5 of the amendment. By way
Yes, it's
of
literally a reverse
prohibiting
racism
various
argument.
kinds of
That's what the
effects.
person,
And so
Bream,
in
he's
Milligan,
representing
we
the
said,
petitioners
a ban
here.
on discriminatory
That's
effects
his argument.
is an appropriate
But he
method of promoting the
doesn't
purposes
wanna say
of the
it's
15th
racism.
Amendment. And as I said, that goes back to Katzenbach, it goes back to City of Rome. And I understand that common ground here, including among the SG, is essentially a desire to take us back to an entirely intent-based world. But that is, that is the thing that we tried to do, that Congress prevented us from doing, and that since the amendments of 1982 has been very clear that that you do an effects test for Section 2 in order to vindicate the purposes of the 15th and 14th Amendments.
It's clear what Congress did. I mean,
No,
it was
this is
using
just
its
oral
enforcement
arguments.
power only.
This
It
is
doesn't have
feeling
the
like an
power
end
to
of
change
session.
that.
I mean,
Sure.
I'll take that label. That's fine.
This
But
is
it
gonna
was-
come out at the
Congress
end.
has enforcement power under
It may
the 15th
surprise me though,
Amendment.
since
But it
it's
was not an
re-argument.
appropriate use of the enforcement power, and even if it was then, it's not appropriate today because it's not congruent and proportional. And that the court has
How?
never
And
held.
what is this kind of, was it congruent and proportional in 1982? Or is it just like suddenly not congruent and proportional
fucking
because it's
part.
40 years later? Like, I never understood our congruence and proportionality test, which, by the way, we have never applied to voting. But even if
That
you were
part.
to apply it to voting, I've never understood it to have a kind of, Congress has to re-up its congruence and proportionality findings every 10 years or every 6 months or every whatever you want to say it.
Well, City of Bernie and that decision.
They keep bringing
holds
up City of
Katzenbach
Bernie,
and
which
City
is
of Rome
not
as
fucking
sort of
applicable
paradigmatic,
here.
Exercises of this sort of scrutiny, although they're much older. But the point is this: those cases
This has never been
were based on a
applied.
strong
Congruence and
factual record
proportionality
about
have
very
never been
particular
applied in the
effects-based
context
prohibitions
of
that
voting.
had just been used for purposeful discrimination. They were using poll taxes and literacy tests, although facially neutral, to purposely discriminate, and they would keep changing them over time to make sure that they kept the discrimination in place. So that was a very unique circumstance, and Congress recognized that in 1982. It said, we don't have the same kind of record that we built in 1965 under Section 4A to get rid of a literacy test in a certain area, or when we expanded that out in 70 and 75. People were actually using literacy tests, and they were using them in a discriminatory fashion. So but none of those remedies stereotyped.
Thank you.
Justice Gorsuch. Justice Kavanaugh. Justice Barrett. Justice Jackson.
So going back to this discriminatory intent point, I guess I'm thinking of it, of the fact that remedial action absent discriminatory intent is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible.
Okay, so Bernie versus Flores is an older case that applies here. It's specific to the 14th Amendment. The holding is if a law that enforces the 14th Amendment rights is preventative rather than remedial, it must be congruent and proportional to the goal that it is aiming to achieve. City of Bernie versus Flores was over religious discrimination in the context of city zoning laws. So let's be clear about what that case is before we continue to listen to this case and why it has no equal applicability as Kagan was stating before him. Sorry, that's an older one, so I don't have it memorized.
See that these processes are
There's
not
a few I do, but
equally
not that
open.
one.
So I don't understand why it matters whether or not the state intended to do that. What Congress is saying is if it is happening, which Section 2 gives us the tools to determine, you gotta
That
fix
part.
it.
The difference is that the remedy under the ADA and other anti-discrimination laws is not stereotyping. We don't then.
It's not race-based. I take your point. I take your point. But you're saying then that if the problem of no access is about race, it's just too bad. Because
Yes,
you can't
that's
have a
exactly
remedy
what he's
that relates
saying.
to race.
Absolutely not, Your Honor.
Okay.
It's not whether it relates to race.
No, that's
It's
exactly-
whether the
no,
remedy
that's
that relates
Jackson.
to race
no,
involves
that's exactly
stereotyping
what he's saying.
voters and making assumptions about their politics and their views and their thoughts.
Oh,
based on
but
their
you can
race. And that's the
partisan and
problem.
racial
It doesn't exist in
gerrymander
those
the
So
other
why,
whole
why do we have
fucking
to change
state?
Section 2? Okay, so fine. You say if it's a remedy problem, why aren't we just focused on whether the remedy here, the
ridiculous.
particular map in Louisiana is predominant, using race, and if so, strict scrutiny applies, and did they narrowly tailor it? I mean, that seems to me to be the problem that you're identifying. The remedy here, you say, is overbroad. It's not using the right factors. It's using race in a stereotypical way. What does that have to do with Section 2 and changing its criteria and adding intent there?
Well, Your Honor, you have to break the link between only using effects on the front end and on the back end using race and stereotyping.
So he
That's
is
what you have to break.
arguing
And so, I mean, this court
Section
warned about that
2
problem
as
this
basically
problem.
not
Okay, I don't see the link, but I'm
constitutional,
out of
which is
time.
not
Thank you.
defined.
Thank you, counsel.
I think this is going to be the Trump lawyer.
Mr. Chief Justice, and may it please the court. I think this court's predominant standard will help clarify a lot of
This
the
is
issues
the
that
Trump
we discussed
admin.
this morning, and will also show why the arguments we're pressing here were neither raised nor rejected in Milligan. So first, under the Constitution, the problem is not the mere consideration of race in districting. The problem is when race subordinates traditional neutral principles and is the factor that cannot be compromised. Second, the problem with Section 2 and jingles is not that it's an effects test. The problem with the statute is, as construed in jingles, it's reaching far beyond anything that can reasonably present a risk of intentional discrimination.
No, this
as
is no
in fact
Pam.
making race predominant, is requiring states to subordinate their principles to find a result. The Robinson litigation perfectly exemplifies this. The Robinson plaintiffs could not show a denial of equal openness for black Democrats. What they could show is that Democrats in Louisiana lost a seat. I welcome this court's questions.
In one of your suggestions in your brief, you mentioned decoupling race and party. One, is there a correlation, particularly among black voters? And two,
Yes,
how do you
there is a
decouple?
correlation.
So there generally is. The way you would decouple them is you look at primary elections, right? You look to see in the Democratic primary, do white Democrats and black Democrats vote differently? And that did not happen here. If you look at the Robinson District Court
Bullshit.
opinion, when they do the steps 2 and 3 of jingle,
It didn't happen because the map wasn't allowed to be used. Because the map never, I swear to God.
and they analyzed racially polarized voting, the court expressly said they didn't need to try to decouple race. And they did that because in jingles, the court never resolved the issue. Justice Brennan said you didn't need to do it, but Justice White refused to join that part of his opinion. And so that's part of the problem here, is that what's going on
The problem is they're arguing something that is not realistically possible. It's sort of this like magic decoupling of race and party. And while in a perfect hunky-dory world that would exist, that simply doesn't, particularly when it comes to black voters, because black voters overwhelmingly vote majority Democrats. Now, we see this more so in black voters, and I'm not trying to stereotype or do anything. I'm just looking at pure statistics here. They overwhelmingly vote for the Democratic Party. So saying you can uncouple this doesn't work in the context of black voters. And if black voters aren't being represented, that's a problem. So this is where all this sort of kind of overlay is coming in, but they're arguing something that just simply won't happen by clapping your hands and saying, you can't do this, because then it just still disenfranchises voters.
Something wrong, they overruled it and passed Section 2. I don't know how we get to redo jingles when this case didn't involve jingles. The district court in this case didn't apply jingles.
They didn't.
It was the district court in the Robinson
They just
case.
said, hey,
It's
you
not
have
the
a high
Robinson's
probability
case that's
that this
before
map
us.
is fucked.
It's this case.
You better fix it.
And so I'm
And they
a
weren't
little
allowed to
bit
use it.
confused.
So they couldn't apply
How
jingles.
do we enter redoing jingles?
So the reason you're there is you asked two questions. One is why it's relevant, and the second is can you do it under stare decisis. So let me address those in turn.
You can do it in whatever order.
Okay. So
Tell me, did the district court here apply jingles?
no, because this case comes up as a racial gerrymandering case brought by the Callais plaintiffs. They showed that race predominated. At
But
which
that
point
has nothing to do with what the court did here.
it does. The reason it does is because once they showed that race predominated, the burden flipped to the Robinson appellants to show that they had a compelling interest.
Right.
They asserted the compelling
Sweet,
interest
Davo.
was Section 2, but if they misapplied Section 2, then they don't have
How
a
would
compelling
you-
But
interest.
we have said over and over again that the compelling interest is in a state believing that it should remedy something, and it can be wrong.
Not as
We
a
have
matter of
said
law,
that. We
no.
have said that over and over again.
You're-
Counsel,
He's
you're
not
wrong sometimes on a factual basis, sometimes on a legal basis.
He
Wrong
is
wrong.
arguing the law
Whatever
with
you think
Sotomayor.
might be the error.
I'm fucking.
If you still think that it's something that's in
He's
your best
big
interest
mad.
to do,
He's
you do it.
already
Your
fucking
Honor,
mad.
that's contrary to this court's
And she
holdings
said,
in
"Bitch,
Miller,
you're
in
wrong."
Shaw 2, and in Cooper. This court has repeatedly said that if you have an incorrect reading of Section 2, that or Section 5 of the Voting Rights Act, that is not a compelling
What case?
interest. The court has applied the good faith standard under strict scrutiny to errors of fact, not errors of law. In Miller and Shaw, the DOJ browbeat states into creating multiple majority-minority districts, and they all thought they were doing it under Section 5. They were acting in good faith. The DOJ was browbeating them. But this court said that is not a compelling interest because the DOJ was wrong about what Section 5 meant.
That hasn't been the allegation here.
That is the allegation here. The allegation here is that the Robinson court was wrong about
That
what Section 2
wasn't
meant.
an
They
allegation
completely
they
misapplied Section
presented.
2, even actually under Jingles, under Milligan, let alone under the proper way to interpret.
The problem is that all these attorneys arguing can't decide what they're arguing about. First guy was arguing against the actual issue. Then we get to the plaintiffs and he's mad about, what the fuck? I don't even remember what the fuck he was mad about. And now this guy's mad about jingles in the application. Oh, the last guy was Section 2. Like, they cannot decide what they want to argue against, so they don't know what to challenge.
Yeah, it's a nice rectangular district. It's very pretty, but it's not compact. And then third, they didn't control for racially polarized voting. So they just said that blacks vote differently from whites, which just basically means Democrats in Louisiana vote differently.
Black people, first of all, let's be clear, black people. And yes, statistically they do. This is documented. And it's not to be like partisan or to be in any way disrespectful, but yes, they tend to vote differently.
differently from Republicans in Louisiana. That's not racially polarized voting. That is not the proper interpretation of Section 2, and it is exactly why Section 2 is leading to racially predominant results, where you're essentially using Section 2 to undo political outcomes, and that is an unconstitutional reading of the statute.
Oh, I'm so sorry. We draw partisan maps and that's not undoing political outcomes? I apologize, sir. What the actual fuck are you talking about?
Jingles, as it's been interpreted, essentially imposes liability based on making the state take race and predominate over race-neutral criteria. Again, using Robinson as an example.
I don't understand. I'm sorry.
So, incumbency protection is a traditional neutral principle. Robinson found liability by requiring the state to discard their race neutral.
But I thought you said Robinson was wrong, so then we just changed that understanding. Why does that create a constitutional problem?
So it's the way it was wrong is it required the state to subordinate race neutral principles to race. And let me use Milligan.
And Jingles required
No, it
that?
didn't.
So
it
the
said
way-
you have.
It was consistent with
All
Jingles.
it said
and
was,
Jingles
hey,
is
you
wrong,
probably
or it
have
was
a
inconsistent
problem
with
here,
Jingles, and we should
and you
say
need
that.
to fix it.
Interpretation
That was
of
it.
Jingles that was adopted in Milligan is the real problem here. And so this is the pages in our brief that Justice Kavanaugh cited a couple times. The fundamental problem is when this court said in Milligan that as long as the plaintiff's illustrative map is roughly equivalent to the state's map, that's enough to satisfy Jingles. What that meant is you're basically telling the state that you have to subordinate your weighing of your neutral principles and go a different direction just because of race. Let me give you an analogy that I think will make this a little bit clearer. Imagine if Congress had passed a statute that said...
Yes. Okay, so they did argue that when black people are about a third of the population in Louisiana, and I believe they have 6 congressional districts, that you shouldn't have one district that is a majority minority. They did make that argument. However, the court just said, hey, you probably have enough evidence here that something is fucked up, so maybe you need to fix it. That is a very dumbed down version of what happened. The 5th reaffirmed. The 5th most conservative circuit ever reaffirmed this.
That would help blacks, even though there's no reason to think that it's either intentionally discriminatory
If you're
or
coming
even
in, thanks
a
so much.
significant risk of intentional discrimination.
But why is intentional discrimination the bedrock? They're not just, you're reducing what is happening to Section 2 to something that I don't think is consistent with what Jingles is actually requiring.
Because the Constitution
And they didn't do a
prohibits
Jingles
intentional
test.
discrimination, and Justice Barrett, as you pointed out, this is enforcement legislation. So we agree it's not an intent test, but it has to at least be
Thank
smoking
you,
out
Ashley.
conduct that presents a significant risk of intentional discrimination. That's the phrase that this court used in Bernie, is the phrase that this court used in Katzenbach too. Again, one way of thinking about this is if you think there's a problem here, white Democrats in West Virginia, they don't get
literally
districts
is
belong to them.
Section
White
2 of the
Democrats
Voting
have
Rights
zero
Act.
representation in West Virginia, even
2
though they're a
fucking
significant
paragraphs.
percentage of the state.
2.
The reason why Section 2, it's being construed in Jingles as a problem, is it's saying that you have to create a district for black
So now they're
Democrats
arguing
that you
that
would
Jingles
never
is
create for
fucked
white
up.
Democrats
Again.
in a Republican state. It's essentially
I
being
hate it
used
here.
as a reverse partisan gerrymander on purely racial grounds. And that is a constitutional problem. And the test we have identified in our brief would solve that problem.
Thank you.
Thank you, counsel. You began, if I'm remembering correctly, suggesting that Milligan was consistent with your position in this case. And then, of course, you've mentioned its discussion of Jingles is not.
Yeah.
I wonder if you could explain that a little further, to what extent it's consistent and to what extent it's not.
Yeah, so most of the arguments we're making in this case were not made in that case and were not rejected in that case. There is one aspect of our argument that is inconsistent with with Milligan. The one aspect that's inconsistent is what I was discussing earlier. The part of Milligan where it said that it's reasonably configured so long as it's roughly equivalent. We think that that is wrong, and we think that that aspect of the opinion is what causes all the racial predominance. Because again, if you take a step back and think about 2 possibilities. Possibility 1 is the plaintiffs come in and their map is superior to the state's map on the state's own principles. Then we think it's okay to have a results test, because in that circumstance, you're not telling the state they have to subordinate their race-neutral principles. You're essentially enforcing their own race-neutral principles in a situation where there is either intentional discrimination or at least a significant risk of intentional discrimination. But conversely, in a situation where it's equivalent, you're basically telling the state,
the whole
look, you could have done
purpose
this either
of
way.
jingles
You want to do it way
is
A,
to
you have to do it way B.
determine
Why? Only
whether
because of race.
racial
That's what
voting
makes it
is
predominant.
diluted.
That's the one aspect
That's
of
the
Milligan
test
that we
it
disagree with.
established.
Thank you. Justice Thomas?
And he's arguing
Justice
that,
Scalia?
like,
Well, I
oh,
think
well,
you
it
may
talks
be,
about race, so it's fucked up.
Too
Like,
hard on Milligan.
is he
because
high?
Alabama in Milligan did not argue that it had drawn those maps based on seeking partisan advantage, right?
I agree, right? And that's why I started my answer to the Chief Justice by saying all the arguments we're making here were not made by Alabama. Alabama made a series of much broader arguments about how you can't consider race at all, the plaintiffs have to draw their maps race blind, you ultimately have to find intent. We're not arguing any of that, and I agree with you. Alabama, for whatever reason, didn't argue that incumbency protection and partisan advantage were the reasons for their map. And after Rucho, it's clear that those are traditional race-neutral principles that cannot be subordinated by Section
Pretty
2.
much what this is
Yeah,
about.
and I think that's consistent with the fundamental analysis in Milligan for reasons that I tried to bring out during my questioning of Ms. Nelson. The first Gingell's precondition, as described correctly in Milligan, is that the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district.
Amanda, the outcome is that
if it comports with
it
traditional
will
districting
not
criteria, and since Rucho
likely
seeking a
offer
partisan
as
advantage
much
is
protection to
legislative
people who
objective,
can
just
be
like
cracked and
partisan-
packed
just
in
like
minority
incumbent protection.
populations
So
out of
therefore,
their area.
that should figure
If
in
it's
the
a bad
first
outcome, if
Gingell's
it's the
precondition.
good outcome, I
Absolutely
would figure
should,
they
and
would
in this
just be
case,
like,
Robinson in particular,
this is a terrible
the
argument.
state did argue incumbency protection. And if you look at what the Robinson District Court said, it actually said that, oh, we satisfied incumbency protection. She still lives in the district. She's going to lose, but she still lives there. That can't possibly be right.
And then again, on block voting, again, the Rucho issue was not involved in Milligan, but if block voting is understood properly to mean voting on the basis of race, but not on the basis of partisan politics, then
that's the
must
real
also
problem,
be
right? Is
considered
that
under
like
Gingell's,
they're
right?
trying to argue
And this is
you can't include race, but you need race to substantiate their claim, so it's antithetical.
And our view of the results test would apply in exactly the situation where racially polarized voting properly
I don't know that
understood
that's
exists.
the goal,
So think of
Tommy,
an area like Harlem.
but I can certainly
You've got
say that will
white
be an
Democrats,
outcome.
Black Democrats, and Hispanic Democrats who
they
all live around
persevere.
the same area, and who probably have at
I
least
could
sometimes
speculate,
different
but
candidates of choice.
likely.
If the state of New York were to draw a map in a way that departs from their normal principles and favors one of those racial groups, that's the sort of situation where Section 2 could come in and say,
okay, I'm so sorry. How is having 2 districts out of 6 somehow like this makes no sense.
well, there's racially polarized voting. You've departed from traditional principles. There's a reason to be worried. And this isn't just a partisan thing. You can imagine the same thing on the Republican side. Imagine Florida. If you have a part of Florida where you have white Republicans and Hispanic Republicans, and same thing, the Florida legislature draws it in a way that departs from traditional principles and favors one or the other racial group. But what you can't have is merely just showing that a Republican legislature favored Republicans with whether or not they're white or black. And there's just no reason in the world to think that the Louisiana legislature would have done anything different in this case if every black Democrat in Louisiana was a white Democrat.
Let me ask you about congruence and proportion.
He's essentially saying that the cracking and packing of minority black voters didn't happen.
Amendment
Despite
allows it to
a
go
very
beyond,
conservative circuit saying,
intentional
yes, sir, I think it
discrimination
did.
For this reason, proving intentional discrimination is difficult.
But intent,
in part because
as a couple of justices have pointed out, Intent is not a question here. He is arguing a point of intent. Intent is not what they are trying to figure out. The intent is not the important part here. It's the remedy that's the important part, if it exists.
It's really hard. It's always hard to figure out what legislative intent is. What was the intent of the legislature in enacting a map? Do you look at stray statements here or there by legislators?
I hate
plus
intent.
the finding
It
of
doesn't
intentional
fucking matter.
discrimination accuses the state of
If you didn't intend to rob a store, but you shoved a chocolate bar in your pocket and forgot about it, you still fucking robbed the store.
To identify
That's how that works.
factors that strongly support a finding of intentional discrimination, and that's what was involved in
And thank
White
you so much
versus
to everybody
Register,
coming in.
which
I really appreciate all of
figured
you.
very prominently in the drafting of the 1982 amendment. So if that's what you're doing, it is congruent and proportional in that respect. Is that a correct understanding?
That is, and if I could just amplify a couple of points. So we agree the Constitution prohibits intent. Congress's enforcement power can let them go beyond that to an effects test, a properly tailored one that gets at a significant risk. And that avoids a lot of the difficulties of actually having to prove intent by a preponderance of the evidence. And if it is actually tailored, if the statute itself is tailored to things that have a significant risk, then we don't actually think you necessarily need to have a temporal limit in the statute itself. So that's why, Justice Sotomayor, for example, the bans on tests, literacy tests, we think those are fine, even though there's no end date in that statute, because those are well-known, highly likely to be intentionally discriminatory laws, even if they're not always. But the problem we have here is that the way Section 2 has been construed under Jingle.
So the argument is that if you're showing minority voters some sort of favor, in their terms, favoritism, or putting them in majority minority districts, that somehow this is discrimination or racism. I'm not going to get into the complexities of this. I've had a super hard time staying impartial with this case. This is one of my, I
can't do it. Including its political objectives. I think the thing that the Solicitor General primarily focused on is confusion about what it means to be predominant. I think we agree completely with them that the phrasing of the standard is race a criteria that could not be compromised? Have you subordinated race to traditional principles? And if you apply that test, I'm not saying that there won't be difficulties on the margins of how to apply it. There will be new cases. Your Honor wrote the opinion for this court in Brinovich. It was the first time that the court had ever adopted a test for vote denial under Section 2. I'm sure there were cases afterwards, but that test was well tailored to the text of the statute and its purposes. And what we're essentially saying in this case is you should do to Section 2 as opposed to vote dilution what the court has already done as applied to vote denial. It should adopt a test that's tailored.
Thank you.
Justice Sotomayor? The bottom line is just get rid of Section 2, because the test you're providing doesn't do anything for the effects test that Congress identified. We did say in Kassenbach, we've said it repeatedly, that legislation need only be plainly adapted to addressing discrimination practices in voting, right?
Yes.
All right? The standard that you're setting is a much different one. It has to substantially be addressing this issue. Number two, what you're suggesting is that people of one race, of blacks in Louisiana, who will have to be 51% of the population before they'll be able to elect another black candidate. Because what you're saying is partisanship is non-negotiable. You have to create maps where you're going to have 6 districts out of 7 always white, because that's our partisanship. That means blacks never have a chance, no matter what their number is.
I wish she would stop saying that
51%.
Black people.
So I don't think that's true for a lot of reasons, Your Honor. So the first is, as I think the General pointed out, even without Section 2, there's no reason to assume that states are going to try to crack every single minority district. And the reason
the illustrative maps showed that a map drawn without
thank you for the
looking
likes.
at
I appreciate
race
everybody
and
for hanging out
partisanship together would have created 2 districts.
Your Honor.
Compact in all traditional ways, it would have been District 2 and District 6 around the Baton Rouge and 2 other counties that were tied historically and otherwise. And politics, you say, not race, is what led the state not to give them another district.
So I'll say several
And
things.
how is that a
First,
good
I don't
argument?
agree with your characterization
How?
that the Western maps were compact. They combined blacks in different parts of the state, just the way this court said.
No,
you
you're
can't do
talking
that.
about the state's chosen map.
No, I'm not.
The map
plaintiff's
that
illustrative map, if
the
you look at
illustrative
District
map
5.
was better. The illustrative map 2 and 6 were combined, but 2, even in the original map, was not all that compact.
Justice Sotomayor, you're, as Justice Alito pointed out, I'm not disputing the compactness of the district. I agree they drew a very pretty rectangle. The problem is that in the very pretty rectangle, the blacks lived in the south and the north. And they took 2 very different groups of black people and
Well,
put them
the
together.
problem is that all of this map is that way. North and
Right,
south,
but they did it
east
for
and
racial
west.
reasons, and the state did it for non-racial reasons.
Well, really, in excluding the blacks, they did it for racial
No,
reasons.
Your Honor, there's no argument for that. As Justice Alito pointed out, the state's maps have been pre-cleared twice by the Department of Justice. So the suggestion that the fact that the prior maps were 5-1 maps is not, there's no basis to say that that was for racial reasons. And again, West Virginia,
That
0
part, Rory,
Democratic
it's been
districts.
dropped a
There's
lot.
a lot of white Democrats in West Virginia. There's just no reason to assume that because there's a large Democratic population in Louisiana.
I'm gonna say, and I don't know if it's because there are like a lot of old fucks on this. Even Sonia Sotomayor dropped it. Like, not cool. It's dehumanizing language. I'm usually like pretty chill as fuck about most things, but that's unacceptable.
That doesn't have a district, that's a racial reason rather than a partisan reason.
If you can't separate out the 2, it's impossible.
But you can separate out the 2. You can control for party, and you can require them to draw a map that meets
Thank
the
you.
political objectives. And again, and the last thing that you said earlier, that means Section 2
And
has
thank
no
you so
effect.
much,
That's not
everybody
true.
who's
The
gifted
examples
and
I gave
liked,
you
and I
earlier
appreciate
about
you all
areas
so
like
much.
Harlem and in Florida, where you have of the same party and of the state that controls that party.
So basically, their argument is, if you partisan gerrymander, you're good, but if race is involved, absolutely not. Like, if it's even involved a little, like if you mentioned race, you're not good.
Republicans or white Democrats won't vote for black candidates.
Right, but if these were white Democrats, there's no reason to think they would have a second district. None. And so what is happening?
Why is that? If Democrats, if white people were being disenfranchised in a minority, like they wouldn't. Are you fucking kidding me? This whole case is built on the non-African American petitioners, 6 of them, being big sad that they got put in a majority minority district. This whole case, the whole fundamental of this case is built on race. The third person that argued was arguing for those exact petitioners.
Perspectives. I mean, you say, well, that's easy to do. Is it the number of incumbent seats that they want to protect? Is it the level at which they think protection is appropriate? Say, I need 55% of the population to be registered Republicans or
Literally,
Democrats.
this is noted as a
Do they get to
racial
say that? Does the
gerrymandering
state get to
case.
say,
Like,
I not only
this
want
case is about
5
race.
incumbents
Jesus
protected,
Christ.
but I want them really protected.
Patriot,
That's one
if you're going to be a
example.
trash
Does the
bag in
state
my
have to
comments,
say that
I'm not
when
even
it's
like, you're
legislating,
probably maybe
or
the
can it come
10th
in
person
later
I've
in the
muted
litigation
ever,
and say that?
but you're getting
Can
muted.
a court, I'm
Okay,
just
love
spinning
you,
out a few
bye.
things for you. You can just respond to them how you want. Can a court second guess those and say, those are not really the state's purposes, that they're just litigation position? I mean, how's a court supposed to handle that? And then I got some more for you.
So the same way this court already handles that in racial gerrymandering cases like Alexander.
Potter,
the state
you
can
came
come
in
with
too
whatever
late
their
for that.
political
It's
objectives are. If
absolute
they want to
shite.
say it's not just a 6-1 map, it's a 6-1 map with a certain percentage because we want to make sure certain people are safe, really safe, and we're willing to tolerate a little bit more risk elsewhere.
Tim,
it's up to them to
there,
say what their political objectives are as long as they are race
THEIR.
neutral. Now,
There.
can a court second guess that? Yes.
Wrong there, buddy.
If they say, look,
Learn
these
to
are
spell
our
if you want to
interests,
say stuff in the
and
comments.
the map as drawn is inconsistent with that in a bunch of ways, a court could say, we don't believe that.
Well, what if the map is consistent with it? Can I still try and disprove it?
Well, no,
That wasn't really, I mean, that's what the map does, but that's not really what they were after.
So if you could try, if you could try to bring an intentional discrimination case and say that it's pretextual.
How about cohesion, right? You say, well, you got to segregate out
This is running
members of
long.
one
We're
race
gonna
or
wrap
another
quick.
based on their party affiliations and crossover voting and how much they really won't vote for somebody of the other race, even if they're the same party. How much cohesion is enough? I mean, very rarely is it going to be that there's zero crossover voting and 100% cohesion, and vice versa. It's going to be areas of gray. And are we then into a business
The
perhaps of
case is up
stereotyping?
here.
So the court's never made clear.
Go
what
look it
level
up
of
if you
cohesion
don't know what they're
necessary.
arguing
I think
about.
the right way.
That's why I'm asking you.
Right. I think the right way to
You're
think about
about
it analytically is if
2
the
hours
plaintiffs
into this
have
argument.
an illustrative map that satisfies our first criteria, right? That they're
Yep, no, this is another criteria.
Right. So assuming they've satisfied that, then the question is there enough black cohesiveness that they can win the district? So you would have to look to see how much black cohesion is there and how much white crossover voting is there. And if together they can predictably and safely win the district, then they've satisfied.
What's predictably and safely? I mean, those are nice qualifying words. I mean, does it have to be just 50 plus 1? Does it have to be 60?
Well,
I mean,
so I think-
how does a judge make that decision?
I think the courts, what they've usually done is looked at how the map would have performed in prior elections. You don't just look at one because there can be.
Oh, you can run thousands of these things. I mean, we've got computers now. I mean, goodness, of course. And you're going to have data points all over the place. But a judge is going to have to draw a line. And I'm wondering how the judge draws that line.
So we have lots of concerns with how Jingles is applied over time, but this isn't one of them. This
This
seems
isn't
to have
Alito.
been.
I don't
This
know
will be
if
the
it's
next problem
Gorsuch
if
or
we go your
Roberts.
way. Is all I'm
I don't
The
think
men
so, Your
voices,
Honor.
I don't.
if
I
your
can't. I have a
concern is,
harder
well,
time
it says let's just
differentiating,
scrap
except for
Section 2
Thomas.
entirely.
No, I'm not asking that. That isn't my question. I'm asking. I'm listening to everything everybody is telling me. I'm asking you about your
Right,
proposal.
and so I guess my point is, if the concern with
Thank
our
you.
proposal
I
is that
appreciate
you will
you.
have to answer cohesiveness questions that require some amount of empirical showing, what's the alternative?
Okay,
And
I got it.
It's
It's always the
Gorsuch.
bear. I'm outrunning a bear. I got it. Okay. Predominance. What does that mean? I know it's throughout our case law, and I know you say it can't be compromised. Is that a but-for causation test? Is that a proximate causation test? What is it?
I don't think it's but for, I think.
Well, but-for can't be compromised means it's an essential component. It wouldn't have happened but-for. Okay, so it's not but-for.
Not but for, the way the court has described it as.
Is it a proximate cause?
I don't think that's the right way of thinking
It's not
about
a
it.
proximate cause. So what is it?
I think the way the court has described it is it's a factor that could not be compromised and where race neutral principles were subordinated to it. So this case is a very easy case to analyze.
David, go
because
cry
the
about
race-neutral
whatever you're mad
principles
about
that
in
become
another
its
live.
protection
We're
were
listening to the
I'm
Supreme
not
Court.
worried.
Calm your ass
I'm
down.
focusing on your test going forward, not this case.
So let me help you this way then, because I think the question is when is predominance not satisfied where race is considered? I'll give you two examples.
Yeah, I mean, under our normal equal protection jurisprudence, we don't ask whether race predominated. We say you don't discriminate on the basis of race, period.
So let me give you two examples where race is considered, but under the predominance test, it wouldn't be satisfied. And that's why, for example, this court has said that the intentional creation of a majority-minority district does not alone show predominance, and we agree with them about that.
Oh,
So
thank
here's
you,
one
Cynthia.
example.
I
The map
appreciate
drawer
you.
doesn't consider race at all, uses race-neutral principles. The computer spits out two maps that are totally equivalent. To pick between them, they say, okay, we'll use the one that has a majority.
But that gives rise to an inference of intentional discrimination.
That part.
There's no other
Intent
explanation
is
that can
not
be
the
provided
fact.
in
Oh,
your
thank
hypothetical.
you.
That's intentional discrimination. That's not predominance. That's
Intent
choosing on the
is
basis
not the
of race.
factor here.
Again, neither
The
of these
factor
court's
is the
formulations
remedy.
of predominance are met on that fact pattern. You can't say
They
that
keep talking
race
about,
neutral
well, this
principles were
intent,
subordinated.
this
They weren't. And you can't say that
Even-
the race was non-negotiable.
Even if the legislature did not intend to disenfranchise voters, based on what we have in Section 2 of the Voting Rights Act, along with multiple other things, they would still have to reconfigure the districts if it shown some sort of discrimination or unduly affected those voters. This is mind-numbing.
I know what it said. I just don't know what it means.
I think it means exactly what I'm saying, that it's not enough for it to be intent. It has to be that race-neutral principles are subordinated to race.
Thank you.
Well, I'm going to pick up right there because I had a lot of questions about your use of the word predominance as well, which the amicus briefs on your side say that word has been hopeless, I think, in trying to figure out what it means. What I've understood it to mean over time in the jurisprudence
David, you don't
in this
even know
area is that
what we're talking
race
about,
does
so
not
go play somewhere
predominate
else.
if the district,
play in the
even
kiddie
though drawn
sandbox.
based on race, is reasonably configured and compact. Is that what you think?
Yes and no, right? So
that's not as helpful.
I know. And so here's the
Laws
issue.
in
This
court
is
today.
the test is whether race-neutral principles are subordinated to race. If you don't comply with traditional principles, then clearly you have subordination. But what this court held in cases like Bethune Hill and Cooper, and we agree with that, is if you just are dead set on drawing a 55% black district, but you manage to do it in a way that's consistent with traditional principles, that is still racial subordination. But here's the really important point for this case. We are not arguing, absolutely not arguing, what Alabama argued in Milligan, which is that the plaintiffs can't consider race and that the plaintiffs can't have 55%.
Thanks, Laura. I appreciate you.
And what does matter
But it
is what the
seems
court
like your position is you can use, the state can use race a little bit.
If we're talking about the state
It's kind of
acting,
like the Baki kind of thing. It's a race.
yes,
It's
if
a
you're
Mil-
talking about the-
I think he's talking
if
about
you're
the
talking
Milligan
the state
case that
acting in the
was
first instance solely
2
apart from
years
Section
ago, I
2,
think,
yes,
2023.
our position and this
Let me
court's position has been you can consider race, and the reason why is because redistricting is a complicated, multi-factor inquiry where lots of the permissible
2023.
factors highly correlate to race, and if you don't have a standard like predominance, as this court recognized in Alexandra, every partisan gerrymander case will become a racial gerrymander.
So in Milligan, very similar to the district court in this case, right? The court affirms the district court's determination that plaintiffs demonstrated a reasonable likelihood of success on their claim that HB1, which is their map or whatever they were doing, violates Section 2 of the VRA. That's the whole point of Robinson. And that's what they're arguing about currently. So, just so we're clear, he's saying, that's not what we're saying. No, that's exactly what the fuck you're saying.
When we say that race can't predominate in the at step one of Jingles, we are not focused on what the plaintiffs do. The plaintiffs can absolutely consider
I
race.
got that.
The court has to conclude that their map is better than the state's map. And then you avoid predominance.
I got that. Okay, so then what I viewed as the real innovation of your brief that we have not considered before, as you point out, is the material on page 25, the political objectives. And that strikes me as new, but also new because we haven't considered it before.
So I think that's right. I don't think this court has ever squarely considered it. I think part of the reason the court is...
What's the rationale for why it's consistent for what we have allowed before?
Because it is another traditional race-neutral principle. It is...
I'll read you the final paragraph of the opinion of the court. Alabama further argues that even if the 15th Amendment authorizes the effects test of 2, which is talking about the VRA 2, that amendment does not authorize race-based redistricting as a remedy for Section 2 violations. But for the last 4 decades, this court and the lower courts have repeatedly applied the effects test of 2 as interpreted in Jingles under certain circumstances, have authorized race-based redistricting as a remedy for state districting maps that violate Section 2. in light of that precedent, including City of Rome, we are not persuaded by Alabama's arguments that Section 2, as interpreted in Jingles, exceeds the remedial authority of Congress. The concern is that Section 2 may impermissibly elevate race in the allocation of political power within the states is, of course, not new. Gerrymandering for remedial purpose may balkanize us into competing racial factions. It threatens to carry us further from our goals in the political system in which race no longer matters. Our opinion today does not diminish or disregard those concerns. It simply holds that a faithful application of our precedents and a fair reading of the record before us do not bear them out here. His whole argument is shit.
Applied to redistricting to the extent it requires the intentional use of race to create districts if there's no change in Jingles. That's your position.
I agree with all of that, except instead of the word intentional, I would say use the word predominant. But with that caveat, yes.
Yes, got that. Okay, last, this is picking up on Justice Gorsuch. I think your Harlem hypo is very challenging because, I mean, you get into elections and you're microanalyzing the data. White Democrats and black Democrats are not necessarily, there's going to be a lot of times differences in that. And you say that triggers the finding of polarization, correct?
Yeah, if there is...
I mean, how big a difference does that have to be?
Again, I think the right way
It's like 10-point difference.
I think the right way of thinking about it is if you start with their step one, which is what would the map look like if they'd done it on race-neutral grounds, and then say, is there enough polarization that the minority group who would have been in that district could have won, then they can satisfy steps 1 and 2.
Thank you.
If there's one last point I can make, Your Honor, which is you had asked a question earlier about the practical consequences of our position. I just do want to emphasize one thing about that, which is if you look at Congress today, there are roughly 60 black representatives. If you look at the districts, there are only 15 majority black districts. So even if we're not even urging Section 2 to be eliminated, but even if you eliminated Section 2 entirely, fully 75% of the black congressmen in this country are in districts that are not protected by Section 2. So it is simply not the case that adopting any of the positions on the side, let alone our position.
Just to be fair, they're not arguing for eliminating Section 2 entirely. I think
Sorry, I'm tired of this argument. It's been exhausting. They're going to get into rebuttal. It's going to go back, and then after this one, I'm doing 2 today.
We're going to have one, hopefully very straightforward
follow-up
question.
is
really
Case v. Montana. It's really good.
You've said, and you said just now to Justice Kavanaugh, and I take this to be in your brief too, that your position would require a modification of Jingles. Is that necessarily true? Is there a way to say it's a clarification of Jingles? I mean, Jingles is a 40-year-old precedent. So, big ask to change it.
Yeah. So most of what we are urging, I think, could be described as a clarification. So we have 3 key points in our brief. One is about how you do recently configured. The second
I don't
is
know,
about how
Wallace.
you do recently polarized voting.
I just followed
and the third
their
is how you
lead.
do the tally circumstances.
Either way, I'm going to have
last
to
two, I think,
break
can
for a
fairly
minute and
describe
go to
it
the
as
bathroom and
clarification,
shit.
Because the court has never really grappled with exactly how the totality works, and it has expressly left open the question of racially polarized voting. As to the first
But
part,
if they
the
do them
recently
right
configured,
back to back,
most of what we're saying
I'll
is
just keep it
consistent with
on.
most of this
But
court's
if not,
cases.
I'll
But after Milligan, I do
cut
have
and
to
come back.
acknowledge that aspect of what we're urging,
Case
that
v.
it can't- it's
Montana
not enough
is
that it
very
be reasonably
interesting.
equivalent, that the plaintiff's
if
map has to be
anybody-
superior, that is undoubtedly a modification.
Sorry.
But I would say it is no greater.
So the one I'm doing after this, because he's annoying and it's already the same argument we've heard for 400 fucking times. Case v. Montana is about whether police have the right to enter your home if they just suspect that an emergency is occurring, like they maybe think that you may be trying to hurt yourself type of thing. Normally that, like, to enter, they're going to need probable cause, things that they're going to need a warrant, but is reasonable suspicion enough? So it's actually a really interesting case, and I'm curious to hear it.
That would require a change to what we said.
No, Alabama didn't argue that. The problem with what Alabama argued is Alabama basically said the plaintiffs had to come up in court and without considering race at all, somehow magically show up with the 50% district. We're not arguing that. It didn't make much sense.
I
so it's not
appreciate
smart.
everybody
they were
so
saying you
much
had
for
to have
the likes and follows, and
drawing.
thank
That was the
you
whole thing about the computer.
so much for sticking
they
it
had
out
some
with me.
weird
You're
thing about computers,
amazing.
which again, is
No,
not what we're arguing.
but it's crucial to this point. Their weird thing about computers was you have to demonstrate as the plaintiff that you have a race-neutral map, and that's what you're saying right now.
It's a very different thing. Yes, they both use the word race neutral, but what Alabama did was something about computers that I frankly don't understand. What we are arguing is simply under the state's own principles,
Right.
their map has to be better. That I do understand.
All right, and then my final question, it just goes to that point, because I'm struck by your, the degree to which your analysis relies on the state's departing from traditional principles. You say you get to Section 2 when they, Section 2 violation when they do that. And I guess I just wonder why that doesn't leave us in a position where you really cannot remedy the effects of race discrimination operating
You
in a
can't.
district based on
If you fuck with
past
this,
discriminatory
it's gonna be
choices.
hard.
In other words, you're still bringing in intent because you're saying you have to intentionally depart
And
from your
intent
traditional
doesn't matter.
principles on the basis of race.
Whether you
and
did
that's
it
what's gonna trigger
intentionally or
Section
not,
2.
it's not-
And I have,
it's not a
for
point
example,
here.
the Louisiana historian's brief, where it talks about how the reason why you have blacks in different places is because
Redlining.
the residential patterns in the state are still reflective of where enslaved communities lived along this particular river system. And that residential segregation, along with disparities in political power, economic status, health outcomes, all of these things
All of it.
are existent today because they reflect institutional choices that are traceable to Jim Crow and reproduced through contemporary practices. That last part is a quote from them. So I appreciate that you want to say when the state comes with their new map.
This is what I was saying earlier, is that like you want to clap your hands and be like, this can completely be racially neutral. But we have a history in this country of like systemic and very overt racism that pushed us into things that we are still climbing out of. While it's not as apparent now, it's not something that we all consider or factor in. We have a history of redlining, economic discrepancies, et cetera, that sort of like they put us in these certain areas that it's hard to step out of. So like you can want to clap your hands and say we should never consider race, but unfortunately when you're talking about minority groups and historically oppressed minority groups, it is a factor. It is, and we don't like it, but it is what it is. And yes, I agree, Tommy, but like to the extent that it was before, not exactly, but yes.
Making a finding that they did it for intentional discriminatory reasons. Now, second, you pointed to the fact that it's possible that these effects stem from long distance.
Can I just ask you, why do they have to depart? What if they just keep on doing the same thing? They're not changing the map. I thought Section 2's whole point was that you gotta offer a remedy. You gotta have a remedy where this thing is happening.
Yes.
So the well-intentioned state with no intent to discriminate says, the census has changed, this is where people live, but we're just gonna provide our same map. And if we can determine that that map, under those circumstances, is not providing for electoral opportunity, regardless of whether they've departed from traditional principles, I thought you had to solve for that.
And I guess our point is you don't.
You don't. It's only where they depart from traditional principles.
It's only where you could say that it's either intentionally
Jackson
or
just
likely
clocked him
intentionally.
so good.
Intent does come in.
You don't have to prove it by a preponderance of the evidence.
I see.
It's any other results test.
Thank you.
Oh.
Thank you.
Thank you,
Now
counsel.
we don't have to prove it by
Ms.
preponderance.
Nelson.
Hi, guys. All right, this is the
28
rebuttal.
months ago, this court made it elusively clear that Section 2 is constitutional and that there needs not be a race-neutral map that is presented.
I think they're
as part
probably
of the
going to take a
illustrative
break,
maps.
but we'll
Many
see.
questions that are presented by my opponents on the other side have been asked and answered in Milligan. What is also clear is that Louisiana is emblematic of the ongoing need for Section 2. For example, we're talking about how close this may come to intent or results. If we look simply at the evidence here in Louisiana, we see that Louisiana had shifting justifications for its map whenever it was presented with a map that met or beat its criteria and gave Black voters an equal opportunity to participate in the process. It rejected those maps. The court in Robinson also relied on the fact that there has never been a Black candidate elected on a statewide basis. Even when white Democrats won an election in 2019, Black Democrats lost. My opponents here would like to make this a partisan issue because they believe the case law will enable their case to prevail, but it does not. This is about race. Section 2 and the Voting Rights Act is laser focused on eliminating racial discrimination from our electoral process, regardless of party. And if we look at many of the Black Congress people who were elected, they came out of Section 2 opportunity districts. They don't have to be majority minority districts. Many of them are crossover districts. And so if we remove Section 2, we also recognize that there
even if they were to have not presented a majority minority district, I swear,
will likely be a resurgence of discrimination because Section 2 plays a deterrent effect. States are drawing maps with Section 2 in mind. In fact, Local Rule 21 in Louisiana says that the state must comply with Section 2. The fact that HB 1, which was the original map, was pre-cleared by the Department of Justice means very little. Retrogression is an entirely different standard from what Section 2 is looking at. Retrogression means the state of Louisiana cannot go backwards. Section 2 is talking about whether there is active discrimination right now preventing the additional opportunities for Black voters who meet all of the jingles preconditions to have an equal opportunity to participate in the process. Requiring plaintiffs to control for party is helpful if that evidence exists, and it did to some extent in Robinson, where we put on evidence about Democratic elections and the preferences of white voters that still preferred white Democrats over Black Democrats. But that is not the only question. If that evidence is available, and I will remind the court it's not often available if there aren't primary elections or if we are looking at more down ballot elections, not just the congressional elections at issue here, that evidence is useful. But if there is significant racially polarized voting, that has already been shown to be probative of intentional of discrimination that comes very close to intentional discrimination. What Congress did in Section 2 was strike a very careful balance of using factors like white re-register, like the Zimmer factors, to bring us as close to a finding of intent without making the full accusation and without requiring that conclusion on the part of court.
Because the intent isn't relevant. This Section 2 doesn't require that the intent be there. It simply requires that if it's found, that they remedy it.
In Bush v. Vera, this court said that it must be particularly concerned about changing its decisions or rejecting stare decisis in cases that involve a sensitive political context like this one. That calls the court's legitimacy into question in a unique way. My opponents here have not done the labor of showing that precedent should be overturned. They haven't addressed Janus, they haven't addressed Ramos. They've simply said that we should overturn or tweak the precedent that governs Section 2. And I would say that there's no record to support that in this case, and this court would be remiss to not require that if it is entertaining any significant modifications of Section 2. Any further neutering of Section 2 would resurrect the 15th Amendment as a mere parchment promise, and we ask the court to remand. Thank you.
Thank you, counsel. The case is submitted.
Let's see what they're gonna do.
Ladies and gentlemen, if you are standing, please remain seated. If you are standing, please remain seated. Thank you.
Okay, so I'll talk about this for a minute. I'm just gonna try and hear what they're gonna do. I'm gonna do Case v. Montana next. Case v. Montana is about whether reasonable suspicion is enough for police to like enter your home without a warrant if they believe that you may have some sort of emergency situation going on. It's a really interesting case, kind of questioning a little bit of a finer points on what cops can do, what they can't do. But yeah. Like how you pointed to Justice Brown and then dog. The fuck are you talking about, Leo? Let's see. I would imagine they're probably gonna take a break. This is like 12:30 there, but who knows? Yeah, I don't know, Laura. That's a weird one for me. Here, I'll do this for now. And then we'll see where it goes. I don't know. The vibes on this are interesting. I feel like, let's see. Let me look at Milligan again. Let's see. Kavanaugh was concurring in part. Who dissented on Milligan? Let's see. Thomas dissented. And let's see what else. God damn, Thomas, you didn't have to write a novel. Sorry, I'm trying to scroll down and find out for you. Oh, he didn't need an appendix. Alito dissented as predicted, and what else? Yeah, okay, so Kavanaugh concurred in part, Thomas dissented, and then Alito dissented. So Roberts, Coney Barrett, maybe. It's just going to depend. I don't know if Kavanaugh will hold, but Gorsuch seems to not have dissented either. So this could be interesting. It's similar-ish. So yeah. Oh my God. Are y'all going to the next argument or not? Let's see. What's the calendar? 1 second. Calendar. Should really put times on these bad boys. Let's see. What case is this? This is, well, it's going to be Case v. Montana, so. What's up?
If they start speaking, I'll drop Cass. The case we just heard was originally heard once in March. Do you know why they brought it back?
Your argument next in case 624, Case versus Montana. Mr. Rowley.
Thank you, Mr. Chief Justice,
Oh.
and may it please the court.
I'll tell you in a
This court has
minute.
never allowed state officials to force their way into someone's home without a warrant or probable cause. It should not start now. There is no liberty interest more deeply rooted in the Fourth Amendment than the sanctity of the home. The court has long recognized that physical entry of the home
I
is
will
the
be
chief
right back.
evil
If
against
my
which
mods can
the
just
wording
help
of
me
the
out for a
Fourth
minute,
Amendment is
I'll be right
directed.
back.
And the facts here well illustrate what's at stake with such entries. The police entered Trevor Case's home without permission, a warrant, or even probable cause, and they ended up shooting him in his own house. Montana seeks to justify this intrusion under the emergency aid exception, which permits a home entry only when an officer has an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. As Montana previously acknowledged, that standard, quote, requires in function, if not in form, that officers have probable cause to believe someone's in danger and requires immediate assistance, close quote. Now, Montana insists probable cause is not the right standard, but it also doesn't defend the reasonable suspicion standard applied by the Montana Supreme Court below. Instead, Montana and the United States asked the court to adopt some other threshold that would permit officials, for the first time, to breach the sanctity of the home when they don't have permission, don't have a warrant, and don't even have facts leading to a fair probability that an emergency is actually taking place within the home. Their proposed reasonableness standard is so vague that not even the state and its amici can agree on what it means. And its open-ended balancing approach invites abuse and confusion, leaving police and first responders without the guidance they need and citizens without the security promised by the Fourth Amendment. The court should adhere to the textual and traditional standard of probable cause. I welcome the court's questions.
Do we normally use probable cause standard outside of the criminal context?
Your Honor, the court has applied probable cause in camera, for example, with respect to administrative warrants and in other contexts as well. I would point to, for example, Wren, where the court applied it to civil vehicle infractions. And so the court has applied it in non-criminal contexts.
What is the objectively reasonable basis standard?
Your Honor, I think the objectively reasonable basis standard applied in Brigham City calls for and really contemplates, sort of lends itself to some standard of certainty. And our position is that that standard of certainty is probable cause, the traditional standard that the court has applied. Yes, Your Honor.
Well, I mean, I'm just asking what it means. Is there any difference between that and probable cause?
Your Honor, we think that the standard sounds in probable cause. The court didn't use those words in Brigham City, and it did not use those words in Fisher. But we do think that the standard echoes probable cause. I'd point, for example, to the language in Pringle, where the court said that the substance of all probable cause definitions is reasonable belief of guilt. And so while the court didn't use the word probable cause, we do think that there is an echo between the standard applied in Brigham City and the probable cause standard.
Well, I was just going to say, when we talk about probable cause, we use it as a shorthand. It's probable cause of what?
So, Mr. Chief Justice, here it would be probable cause that an occupant is seriously injured or imminently threatened with such injury. Ordinarily, it would be probable cause to think a crime is being committed, but right. Here, as the government explained in its brief in Brigham City, the object might change. But the way that the standard applies and the level of certainty does not.
Why isn't it something like probable concern or reasonable concern? It seems to me that you're taking.
Sorry, guys, I had to take a break. Thank you.
And applying these things just because we're familiar with them and because authorities are involved. I mean, did they enter this home because they were concerned that, I forget the name of the individual, would harm himself? Or was it because they wanted to arrest him for a particular criminal activity?
So, Your Honor, the dispatch call was for a wellness check. But I
that's the
to
question,
get to your original
right?
question, the court has applied
unreasonable
that
search
cause
and
standard,
seizure in the Fourth Amendment are kind of
in different contexts. For example, when a civil vehicle infraction, that's not a crime, and the standard still mapped onto it. And we think that it maps on to the emergency context quite well, because officers and first responders don't have complete information. They're just trying to assess whether there's an urgent emergency that is happening behind the front door, and probable cause would help them do that.
You'd say urgent emergency. I mean, let's just say as a patrol or whatever, he looks in the window and there's somebody who seems to be in some distress. Now, is he supposed to say, I can't tell if, he has a pain is, or if he's having a heart attack or whatever before, entering?
Mr. Chief Justice,
or even just lying on the ground. Why is that person lying on the ground?
Well, the court said in Fisher that you don't have to have ironclad proof that somebody is dying before you go in.
Well, they're searching for a person.
But the standard is under the emergency aid exception as defined in in Brigham City.
So, like, here's the problem here. An unreasonable search and seizure, whether it's for a person or property, if you are seeking a person to confirm their safety, that's where it can be problematic in terms of the Fourth Amendment.
Be seriously injured or imminently at risk of such injury. And so I do think the court has fixed the threshold, but it said you don't have to have ironclad proof, and that's consistent with probable cause because, of course, probable cause also does not require ironclad proof. What it requires is a fair probability or a substantial chance, and we think that that strikes the right balance given the important and really fundamental interest in the sanctity of the home.
I think it's critical. If there wasn't probable cause, then there was nothing the police could do. They couldn't get a warrant either, right?
Your Honor, there is a civil warrant available in the state of Montana, but to answer your question, in these circumstances, given the risks, I think what Your Honor is asking is whether they could do it immediately, and it would not be easy to do that.
No, it's not a question of whether they could dispense with the warrant requirement. If there's no probable cause, then they can't get a warrant. And it seems to me that if the police could not enter this house based
Fanny,
on the facts that they
I don't
knew,
know. That other
then I don't know
case
when
is going
police
to
are ever going to
be
be able to enter
different.
a house.
Alito's
to prevent
definitely
somebody
dissenting.
from
I'm thinking of
committing
Kavanaugh
suicide.
dissent.
Your client's
Thomas,
ex-girlfriend calls
strangely,
them, and
a
she
little
says
different than
that he
Milligan,
said
but
he's
he'll probably
indicated he was
dissent
gonna
as
kill
well.
himself. He was going to get a note. She heard him racking the action on a handgun. Then she heard a popping sound. Then the line went dead. She was screaming on the phone. He didn't answer. They go to the house. They try knocking on the door and yelling. They get no response. They see empty beer cans. They spoke to a neighbor who said his vehicle was parked outside. They shone a flashlight through the window. They saw his keys on the table alongside an empty holster.
I have the wrong background up. Sorry, guys.
Note. I mean, what more did they need?
Justice Alito, I think what's critical here is the officer's extensive knowledge of Mr. Case. That knowledge goes back decades as to a couple of the officers. Chief Sather testified that he'd known Mr. Case his whole life. Captain Heffernan also.
He had.
All right, sorry, y'all. I got it fixed.
Carried through.
My bad.
There were no circumstances under which they could ever enter his house.
Sorry, guys.
To prevent him from committing suicide if he threatened again. Is that your position?
Our position, Your Honor, is as assessed by the officers on the scene.
They don't vote on the
Based
same
upon
day.
their prior
They'll
experience
issue a
with them,
ruling at some
with
point.
Mr. Case, including, I would note, precipient witness
Sorry, guys.
experience, they drew the inference that he was unlikely to shoot himself, and
But I
that
find
he.
your argument very odd, right? We're trying to think about a standard here, and I would think that the relevant criteria are the amount of information that the officers had.
Yes.
And the threat to the individual, the actual nature of the emergency. And so in this very situation, I'm thinking the fact that they had a lot of information about Mr. Case actually hurts your cause, not helps you. I mean, I understand you want them to draw a different inference about it.
I can agree that this is not a sympathetic plaintiff. Like, I can agree to that term. Like, this is kind of Rahimi-ish in that, like, there's a lot of reason why if you were looking at this, it could be problematic.
information and threat or risk, this seems like it's pretty high.
Justice Jackson, I think that information led the officers on the scene because there are deliberations that are captured on body cam.
Thank you, everybody,
Those
coming in,
deliberations by
liking,
officers
sharing
with
all the
quite a lot of
shits.
extensive experience with Mr. Case are powerful evidence that Mr. Case was unlikely to shoot himself because they're talking about him provoking a confrontation with the police. And I would just quote, for example, Police Chief
Interesting
Sather
to note,
says
this person in the past had made several threats of harming himself.
Or Sergeant Pasha,
That's
who
why I
says
said he's
been
not
suicidal
exactly a
for-
sympathetic
Okay, setting
plaintiff.
aside this particular case, let me just try to understand the standard that you want us to apply.
Yes, Your Honor.
You say that it should be probable cause. I thought we already had the emergency aid exception requiring, quote unquote, an objectively reasonable belief that an emergency is occurring. And I didn't hear that in your recitation. You said you want it to be a fair probability or a substantial chance. So can you just describe for us or explain why it would need to be a higher standard than objectively reasonable belief?
Because you're entering a
Your
person's
Honor, we think
home.
that the objectively reasonable belief standard really lends itself to some standard of certainty, and we think that the traditional probable cause standard
There are
is
criteria
the appropriate
police
formulation.
have to meet to enter your
objectively
home.
reasonable belief. in
Usually
your
a
view,
warrant.
if you meet the threshold of probable
If
cause.
you ask for one.
Yes, Justice Jackson. And I would say that the fair probability language and substantial chance, that's all from Illinois v. Gates. Those are just principles associated with probable cause. And we think that they make a lot of sense in this context, as they do in the context of investigatory searches and seizures.
I wonder if this is just a labeling exercise, Mr. Rowley, at the end of the day, because when we're interpreting the Fourth Amendment, we often look at, what the common law has been, what positive law. We don't always, but we often do. Katz is another thing, but Jardines tells us to look at the actual law. And one thing I'm struck by here is, a private person would have a good necessity defense to a trespass claim. Always, historically, it appears, from what I can tell, when it reasonably appears necessary to prevent serious harm to the occupant. And that's almost exactly what Brigham City says for officers. And officers can't have any fewer rights than a private citizen to enter a home to render assistance. Now, that doesn't give them a license to go rummage about the place for crimes, but it does give them a license to enter to render assistance.
But ostensibly, if an officer just says, hey, I really thought this was happening, would it give them allowance without a warrant to enter a person's home? Like, you also have to look at the potential for abuse here, right? Like, I'm not saying it would happen, but I am saying that police have been known to target people, so let's not act like this is not a reality.
Example, the common law of search and seizure recognized the law enforcement officer's authority to break open the doors of a dwelling. So it's what was the constable's authority at common law?
But it doesn't. The constable doesn't have fewer rights than a private citizen. We've often said that.
Justice Gorsuch, when the court talks about that, about the ability of officers to do the same things that an ordinary person is doing, ordinarily it's talking about whether there's a search, whether the Fourth Amendment is even implicated.
Right, that's another whole question, whether there's even a search here. But I'll take as given that there's a search for the person to render assistance, but not for other purposes. It's not a license to go rummaging about the place. It is
That's
a
an
license
interesting
perhaps to
point,
enter and
Corey.
search for the occupant who's facing a serious risk.
But the necessity defense was a broad-based common law tort defense, as my friend points out in.
Okay, but like, Henry, you made a good comment, and I want to just touch on it briefly. It said that officers shouldn't have less rights than a private citizen. If you're a private citizen and you wish to enter another person's home, what do you need to get? Permission, right? So police have like certain abilities, but should they just be able to say that they thought you were going to hurt yourself and enter your property? Like, I think it's a good and reasonable thing that they need a higher level of scrutiny to this.
Cites the restatement.
Yes, okay.
But at common law, you had to be right that the necessity actually
What's
obtained.
your best authority for that?
I would point to the state's own cases. I would point to Rex. I would point to the Wakeham case. In general, at common law, you had to be correct. Now, there is this reasonableness gloss in the second restatement. I would note that the state hasn't pressed this argument. It hasn't suggested that there ought to be some generalized necessity defense that would be drawn from modern day tort principles. The way this has come up in the briefs is, as you suggested, is by way of common law. Yeah. And again, I think that the relevant question is, what was the authority of constables? And they had all these specific rules that are set out in the treatises.
Thank you.
I thought the hesitation of the officers that you pointed out before showed care before rushing in and thoughtfulness by the officers.
I don't think it's inherently dangerous. I think
Your Honor, I think that the delay, there were deliberations that were quite extensive, and it took them 40 minutes to go in, as the dissent in the decision below noted. That amount of time is inconsistent with the kind of urgency you would expect if what you thought was happening was somebody was either bleeding out or was about.
Well, if they, after deliberations, walk away and he commits suicide, I mean, what are you thinking then of the officers?
That would be unfortunate and tragic, but we are trying to strike a balance between them.
And the officers need some clarity, I would think, in circumstances like this about what they can do and what they can't do. And it seems like they thought about it carefully and decided that the risk was sufficiently high, to Justice Jackson's point, and that harm that would occur was sufficiently substantial that they should go in. And by the way, they're going in at great risk themselves.
Of course.
And this is not, as Justice Gorsuch is pretextually looking for a crime or going in for some other pretextual reason or going into,
So I'm going to read this. This is from Scotus blog. The Fourth Amendment has never imposed a rigid warrant or probable cause requirement. Instead, it says the key question is whether the search and seizure is reasonable. The Supreme Court's decision in Brigham City contends and reflects this standard, applying the objectively reasonable standard in a case involving a warrantless entry provided emergency aid, just as the Montana Supreme Court says here.
He was going to try to shoot it out with the officers, and
Sorry,
that
this is a super nuanced case, so I apologize for the pauses.
On the scene. What he says shortly after arriving is, last time we were here, he said he was going to shoot it out with, and he mentions another officer and I, and then later on he recounts another incident where Mr. Case tried to provoke a confrontation.
I'm sorry,
on his perception.
Sorry about that. On the articulation of the standard do you have examples where under the current law officers would go in, but you think under your test they wouldn't and shouldn't and couldn't go in?
Well, Your Honor, I think the swatting example that we cite in our brief is a very real concern. It's a pretty commonplace concern where somebody calls, and under the United States theory, I think it's at page 22, where you would use the severity of the threat to ratchet down the level of certainty that's required. If somebody made a swatting call and said, well, there's a bomb inside the house,
Thank you,
it's a pretty big
in.
bomb. I walked by the house and I'm worried that it's going to blow up the block. You wouldn't even need corroboration. You could just go in. And so we think that just requiring fair probability or a substantial chance and some corroborative work, and I think in a lot of heartland scenarios, the police would have that and would. Yes, Justice.
Please,
well,
I'm
this
sorry.
isn't about
ICE.
ICE. This is just about
Please.
local police.
And one of the things that strikes me here is the term probable cause is not itself self-defining, and most of the way we know what probable cause is because we have a body of case law that talks about it, and it talks about it in an investigatory criminal context.
This is Sotomayor.
And in this context, that way of figuring out whether there's probable cause just disappears because that's not the context we're in. So I guess I'm wondering whether then taking a term from a context which has...
So it presents an interesting dichotomy, right? If you fail to act, are you serving public safety? But there's also abuse potential and the fact that you need generally a warrant to enter a home. What is the threshold here? Which is something that the Brigham City case didn't necessarily solve. What is the threshold?
Do you have to have an objectively reasonable basis for believing that somebody needs emergency help? And I guess what I'm saying is maybe in those two cases we did like the best thing possible and we're not going to be able to do anything better.
So, Justice Kagan, the court's always been reluctant to adopt a third standard. I think in Montoya it said,
well, we did adopt a third standard, or, a third standard. I mean, we used different words for this different context. And why not just leave it at that?
Because, Your Honor, it produced a lot of confusion in the lower courts, as we explained in our cert petition. You had a significant number of circuits and states that applied a lower standard akin to reasonable suspicion, like the Montana Supreme Court did here. You had other states that applied a probable cause standard. And we do think that given that this situation is so recurring and that...
But why not just say, this is a different context, our probable cause precedents are pretty much irrelevant and can't help us. We think we got the standard right. That doesn't mean...
The whole problem here, Commissioner, is that they couldn't sufficiently establish that anything was going on other than the ex-girlfriend said something was going on. If my ex can just call and say something's wrong and I need you to go over there, and I'm like not answering my door, and then police can just come in, that's a problem. What if I'm in the shower? I'm gonna let everybody know. If I'm in the shower, I can't hear you
to
if you're not.
Officers and first responders. And while probable cause hasn't been applied by all courts, it actually has been applied by a significant number of the lower courts. In this specific context, the general principles that apply there when you're assessing probabilities, comparing the relative strengths of different sources and information, those map on pretty cleanly. And even if the court just drew on concepts like fair probability and substantial chance, that would actually be helpful.
And fair probability and substantial chance, why are those any better than objectively reasonable basis? I feel as though we're just substituting, your terms for our terms. So these were our terms. We used them twice. Let's use them again.
Because reasonable basis to believe, we submit that it lends itself to some standard of certainty, but it doesn't spell it out. And for officers and first responders who are trying to figure out, it's pretty dangerous to go into a house as the common law sources recognize, as officers express concern about all the time. And so you need some level of certainty for officers and first responders to decide, look, we know enough, there's a substantial chance that somebody is seriously hurt behind that door. And so it makes sense to take the risk. That she called and said he was suicidal. And we think that standard is certainly preferable to a reasonableness standard where you're balancing
where does it go from there?
Interests on the ground the way the state in the United States have suggested. If I might, I would just say that the court has always expressed concern about
so, Donkey, I'm not going to address that here because I'm just addressing the specifics of this case. But if you want to catch me in a live later, I'm happy to have a discussion about
Justice
it.
Barrett has a question.
Yes, Your Honor.
Oh.
Counsel, I think we're fighting about labels, and you got to the point, but you keep resisting it, okay? The court below did not use our Brigham City standard. It used a reasonable suspicion standard. I'm quoting from itself, from the decision below. Objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need. Reasonable suspicion, as we've defined it, means a particularized and objective basis for suspecting the particular person stopped of criminal activity. So they use a standard akin to reasonable suspicion.
Yes, Justice Sotomayor.
So what you're saying is, whatever standard we announce, we should vacate and remand to go back. And the question becomes, how is Brigham City different than probable cause?
This is specific because
subjective?
I guess case freaked out because people are in his house. Case was charged with assault on a police officer. He sought to exclude all evidence obtained after police officers entered his house without a warrant. This is where this becomes like, what the fuck?
Objectively reasonable basis for believing
because if
that's
somebody,
a reasonable ground.
I see this the way I see no knocks.
Seriously injured or
if you bust in my house, police or not, at 3 a.m,
Justice Kagan was
I'm going to be armed.
This is, in my mind,
problems are going to ensue.
Tell us what the objective facts were.
It's just not happening.
Correct?
Yes, Your Honor, and certainly on.
For believing that the occupant was seriously injured or eminently
I
threatened
agreed,
with
Commissioner.
such injury.
Yes, Your Honor, I would just say that formulation in Brigham City did generate a bit of confusion in the lower courts, even though we submit that it
I'm
is
always a
consistent
problem,
with
Davo.
and really resonates with probable cause.
Well, it doesn't resonate with reasonable suspicion.
It does not, and we would be entitled to a remand on that ground, but I want to make sure I get to Justice Barrett's question.
Yeah, thank you. I think it's very difficult because we talk about how much information the person has. I think it can be more pertinent in the situation how little information they have. I mean, think about an officer who walks down the regular beat and there's a picture when there is some person lying on the sofa that looks like he's, kind of an awkward position and keeps going down, and 2 hours later comes back, it's the same thing. He knows nothing about
If
it
it's
except
2
that
in
the
the
guy
morning, they're
appears
probably fucking
perhaps to
asleep.
be
Leave them alone.
dead or passed out or something. So he knocks on the door, he knocks on the window and gets...
So there is a difference between some sort of like significant medical emergency, right? Like a heart attack. And then somebody who the girlfriend says they may do something to themselves, but you don't know whether, like, those are different things. There's a different level of abuse there. If you call for a welfare check on somebody like who's 90, I realize that people think that like all these are the same, but there's nuance to this. And you have to look at the potential for abuse.
Something's wrong. He hasn't moved in 4 hours. It doesn't look like he's taking a nap. But
it's 2 in the
And
morning.
then what happens? I mean, then does he have
From his own
sufficient basis
admission
to, justify the search that led to the illegal drugs? So he doesn't know anything. I mean, maybe if he knew a little more, or maybe his regular habit is to go to the pub at night and...
Thank you so much,
That's why I
everybody
find it
coming
very
in.
difficult
I
to
appreciate
articulate
all
a
of you.
standard. I mean, I don't think it can be based on a probability of something going awry, or because you do want police to be, on the lookout for things that might be dangerous, even if it's not crime.
Thank you.
Certainly, but the court has always said subjective intent. So you might well be concerned as an officer or a first responder or even an ordinary citizen that something's going wrong inside the house, but there could also be innocuous explanations, even...
Your reasonable concern as a private citizen does not give you the right to enter anybody else's home without their permission. I just want to say that again. As a private citizen, you can't do that. Now, police have a little bit more leeway, but you should still be following procedures and not just be able to run into anybody's house because you're concerned.
And at least it guards against unnecessary and needlessly dangerous confrontation.
Justice Thomas? Justice Alito?
What is the substantive difference between the words that were used by the Montana Supreme Court and the words that we used in Brigham City?
So, Justice Alito, what they said was objective, specific, and articulable facts from which an experienced officer would suspect that a citizen is in need of help.
What's the difference between that and what we said in Brigham City?
Reasonable basis to believe that someone is seriously injured or imminently threatened with such injury is different because it doesn't use the word suspicion. And I think the dissent is right to say that the words used in the majority opinion below sound in Terry. Not just the use of the word suspicion, but even the specific and articulable facts. That's Terry-type language. In the footnote that accompanies that standard, the majority analogized and said it was comparable to the Ninth Circuit's exigent circumstances test, but the language is quite different, and it is not the Brigham City language that Justice Sotomayor quoted.
No, I had a couple more questions. I'm puzzled by your explanation of why the police did what they did. Why did they go in your view?
Why do I think subjectively? I think that they treated it as to be honest, as a community caretaking exercise.
To Commissioner's point, although some counties are a little laxy-daisy, for the most part, if you need a warrant right then and there, you're going to be able to get one pretty quick. Like, I'm not saying it's going to happen like that, but within a pretty reasonable amount of time if it's some sort of serious situation.
Directly, he wanted to commit suicide by police. So they said, well, all right, let's go in. So he will pull a gun on us and then we will shoot him. And if that's what he wants, we're going to oblige him. I'm totally puzzled by your explanation of what you think really went on here.
Justice Alito, I think that risk is the risk that was focused on in the on-the-scene deliberations. I'll just quote again, Sergeant Pasha. He's been suicidal forever and he hasn't done it, but there have been several times when he's tried getting us to do it. Later on, Sergeant Pasha says, I'm scared that maybe he didn't actually shoot himself because he can't, and he's tried suicide by cop before, and
So think about this. If somebody is intent on suicide by cop, why would you as a cop enter? Like, just think about that in a reasonable manner. I'm not even talking about a legal manner right now. I'm talking about all of you. Please take a second and reflect on why, if you as an officer know that this person in your community really likes the idea of suicide by cop and has apparently attempted this before, why the fuck would you enter that house? To protect someone from harming themselves. Why? I'm just saying, speculating here.
on the scene assessment by officers who knew Mr. Case and the risk that they thought was the serious one. It was the risk that he was going to provoke a confrontation. I mean, so
if we write an opinion and we set out the facts of this case and we say, well, it has to go back to the Montana Supreme Court for them to apply the Brigham City test. Will it not be the case that police, those people who instruct police officers are going to say, wow, if the Supreme Court thinks that this is even a close case, it has to be sent back to the Montana Supreme Court. We don't know when you can ever go in and try to prevent somebody from committing suicide unless you literally see through the window the guy's got a gun to his head, or they see
Hi, Mike. Yeah, if you don't like how I'm listening and doing this, you are welcome to go watch this on Scotus's website, free of interruption.
dead body on the floor. So look, let's do the safe thing. We're just not going in unless we've got absolutely ironclad proof.
Justice Alito, three things. The court's already said in Fisher you don't need ironclad proof. The second thing is, of all the Supreme Court justices on the Montana Supreme Court, there was not a single justice who voted to uphold this search under a probable cause standard, and 3 justices said it did not meet probable cause. And the final thing, I again would go to the officer's own assessment. It is an unusual case because they had so much information about him, and it's not just that they knew him. One of the officers was a precipient witness, was there at 2 of the prior incidents.
All right, thank you. I get it.
Justice Sotomayor? Counsel, that the state court is applying a lesser standard than reasonable suspicion. It cited the Lovegreen, its own precedent, Lovegreen.
Yes.
And in Lovegreen, it said it characterized community caretaking stops as the least intrusive category of stop, even less intrusive than a Terry stop.
If cops are walking into your house,
that's right, Your Honor.
And that's not the standard we set in.
Less
it is not. And
now, stop trying to help yourself. I've gotten the point out, right?
Cassidy, I've been doing it forever.
Let me get
so
to the second point.
If they do, they do.
Brigham also said the manner of entry.
I agree, Commissioner. That has other implications,
okay.
And they apparently did
the
know
one
this
thing that nobody ever
suspect,
discussed
victim,
here,
whatever you
including
want to
Justice
refer to him
Alito,
as, pretty
is,
well. Oh no, you're fine, Cassidy. No worries.
Drunk.
I'm I'm just not too worried about it.
Your
Like,
Honor, the call was that he had been
for some reason, if you
drinking.
do the
And
little
all of
box
these
thing,
calls
it doesn't
to the police
flag
have
you.
been-
But if
nobody
you're
thought
like
of just
on
letting
the
him
screen,
ride
it,
out
I
his
don't,
own
I don't
SUV.
even know. TikTok's
No, Your
weird.
Honor, there's a comment on the tape. I believe it's Officer Lindstedt who poses the question, do we leave him? But it is ambiguous as to what he's connoting.
All right. Now, they also didn't think of, instead of death by suicide, since he never pulled a gun on anybody else, okay, getting medical personnel to go in, which lots of divisions do on suicide cases, don't they?
They do, Your Honor. Here, I just would note that Officer Lindstedt still did ask, should we stage medical? But I don't think that they did that, and there was no further discussion.
That's the point.
Yeah.
They didn't try to call, they didn't do anything except
Yeah, why wouldn't
not get a
you?
warrant and break it,
If you,
correct?
That's right.
So they took about 40 minutes to actually enter the home while they're knocking and looking through windows and all this other shit, right? So this is actually in what happened in the case. They took about 40 minutes to enter this house, right? They don't call EMS, they don't call backup, like, and you're telling me that you entered this home and had reasonable suspicion that this person may have harmed themselves or be trying to harm themselves.
Of the guns.
Right, Justice Sotomayor. I would quote the dissent. What the dissent says is all the officers on the scene stated that it was unlikely case required immediate aid, but rather was likely lying in wait for them to commit suicide by cop.
So
No, I
They
agree,
could
Watson,
decide,
but
not
you
us,
could have been there
on
after
these
police
facts,
entered and
whether
secured it.
it
That's all I'm
meets
saying,
the
is that they didn't even call
standard.
the backup in.
Yes, Your Honor.
what we do know is that the Montana court used a different standard.
It's live
Lower than
right now.
reasonable suspicion.
That's right.
Thank you.
Justice Kagan, Justice Gorsuch, Justice Kavanaugh, Spirit.
One question, and maybe Montana can answer this, weigh in. if you
Yeah,
don't
the
know.
Watson, that was
Would it be
my
normal or best
thought as well.
practices to
I
send in just
appreciate
medical
that.
personnel and someone has cocked a gun over the phone and is known to be armed?
No, Your Honor. I believe in those circumstances, officers would be called to the scene.
Thanks.
Justice Jackson.
In those circumstances, would you think there was probable cause? Setting aside the quirky details of this case and all the stuff the officers knew, under your
If he had done it on the phone with the police or EMS, yes, certainly there's probable cause there. But as far as I'm aware in this case, this is an accusation coming from the girlfriend, ex-girlfriend of this person.
probable cause standard, if we just had the girlfriend call and what they observed.
It's
when they got to the
Montana,
scene.
Watson.
If they actually, I want to be careful because if what they actually got was a call that said not a pop, but
Well,
there was
Tom,
that there was
scroll.
a gun. The action, as Justice Alito suggested, was engaged, and there was a.
Really, it has to be that detailed.
Well, I mean, a pop could be anything over the phone. I think it's different if there's slide action or you can hear the gun being engaged in some way.
I don't want to belabor this. I guess I'm just trying to isolate
Sure.
suicide by cop knowledge and find out whether, under your own test, all the stuff up to that point would count. And you're just saying we don't have probable cause because of the suicide by cop scenario.
Yes, Your Honor. It's all the information that is countervailing about the risk.
Thank
yes,
you.
Your Honor.
It's the nuance of the case that makes
Corey?
this different.
Mr. Chief Justice, and may it please the court, this court should affirm the judgment below for 3 reasons. First, the Fourth Amendment protects against
is
unreasonable
rolling pretty
searches,
quick.
not all warrantless ones. The framers enshrine that tradition of reasonableness, not a rigid warrant rule, in the Fourth Amendment. At common law, officers and private citizens alike could enter the home as required by necessity when life was at risk. Petitioner's rule would turn that structure upside down. He asked this court to graft the warrant clause's probable cause requirement into the reasonableness clause itself.
So Montana's essentially arguing that if there's a necessity, fuck your Fourth Amendment. They don't need a warrant. They don't need to prove their probable cause in court. Just fuck it. Like, let them go in. Crazy.
And flexibility for emergency aid cases. Conversely, a rule demanding probable cause of peril would force officers to stand
Well, thank
outside
you
a
for
dying
everybody
man's
coming in. I
door,
appreciate you.
calculating legal thresholds instead of saving his life. That's not what the framers wrote, and that's not what this court has ever required. The Montana Supreme Court applied the rule required by the Constitution and this court's precedents. Officers
Tony,
may
that's a
enter when they
problem
have an
in this
objectively
case, is
reasonable basis to
that it
believe
wasn't.
someone inside needs immediate aid. That standard is faithful to text, history, and common sense. I welcome the court's questions.
Did the Montana Supreme Court cite Brigham City?
So to clarify,
It cited its own case law, and it relied
my
on
preface
Callais,
is a bit more
which
nuanced.
relied
Like,
on Brigham City.
I was
so-
being very
There
broad,
seems to
but
be a
like,
disagreement between
if
you
you're
and the
saying
petitioner as to whether or not
that police can enter your home if they
applied
just
the Brigham City
suspect
standard.
that you
It
may be
applied the
doing
totality of
something
the
to yourself.
circumstances about whether
Well, what's
officers
to
had an
stop them from
objectively reasonable
abusing that
basis
privilege?
someone
That's why I
inside
like
needed
that there's a
immediate
little
aid.
bit of
And so
separation
it
here.
applied the words of Brigham City.
Isn't it our normal practice, though, if we're not certain about the standard and we state a new standard, that we send it back?
Yes, Yvonne, I'm very aware
Yes,
of that.
Your Honor, in some instances, but I think it's very clear what standard the Montana Supreme Court applied here. And the facts are particularly strong that whatever standard this court lays down, the facts here satisfy it, that the officer's care had an objectively reasonable basis for believing Mr. Case needed immediate aid.
Would it be helpful, do you think?
Sure, Thor. I'm being paranoid about people's rights. Yes. Yes, I'm super paranoid about protecting everybody's rights.
To clarify, I mean, there's some ambiguity about what the standard was that was applied. So we don't care about that, okay? It's what we said in Brigham City. And then apply that standard to these facts. We don't have to, we could send it back. But would it help to provide guidance to confused lower courts for us to use a concrete set of facts?
So the lawyer from Montana said that a person or constables alike could enter the home at the time of the founding because of necessity. But that is not the case now. We also have the Fourth Amendment, which protects you from unreasonable search and seizure. But a private person cannot enter your dwelling without your fucking permission. Regardless, they have to ask police to intervene. Police do have a little bit more leeway in this, but just a suspicion that you might be doing something to yourself can be abused. And that's what's problematic about this whole case is like, when do they get to enter? What is the threshold of suspicion you need to meet?
The reasonableness standard at the time is that we don't, in tort law, we don't get the full reasonableness standard until 1837 in the Vaughan case in England. But Cook is writing in the 16th century about applying the law of reason to the reasonableness of the common law. And so implicit in jury and judicial verdicts at the time, the concept of the ordinary person and reasonableness is baked into the common law in England.
Thank you
and the
so
common
much,
law
everybody
here,
coming
and of
in,
course,
liking,
textually in the
sharing.
Fourth
I
Amendment.
appreciate every
follow the
single one of
restatement.
you.
We follow the second restatement, Your Honor.
Counsel, we're talking about this as an emergency situation, but there's a lot going on that doesn't look like an emergency.
They're not
right? I
asking
mean,
them
they
to
get
lower
there,
the bar, Alec.
walking
They're
around for a
asking
while,
them
then
to
they get the
have
boss to come
a
down,
threshold clearly
call for
set
somebody else
so
who's
that
still there, and then they go get a body
people
shield.
are not subject
doesn't
to
have the
basically
atmosphere of,
people
we've
coming
gotta
in
get
their
in there
home
right
and
away.
then they're armed because, oh
And
shit,
I
somebody's
wonder
here
if
at
that
midnight.
detracts from the idea that they had
This
sufficient
guy
justification.
eventually got
And
assaulted
particularly
on an
since it- as
officer
Lisa had
because he
said,
was like, what the fuck are
the
you doing in
emergency
my
would come
house?
in if the officers came in, and then you'd have the question of suicide by police.
Well, Mr. Chief Justice, I would certainly agree that at some point, if they did wait too long,
Thank you, Commissioner.
that would cut against an emergency. But in this case, I think the timeline is very important. Officers arrive on the scene at 9:14 p.m. His ex-girlfriend arrives at 9:18. They do a knock and announce. They knock several times, and they spend the next 20 minutes trying to verify the facts that she communicated to them in this case. And it's at 9:34 p.m. that as they're doing the search of the outside of the house, that they identify the suicide note when they flash their flashlights through the window. And so they spend about 20 minutes trying to verify.
I don't think that they ever verified that it was a suicide note. Let me look through my notes on the case, but I don't think they ever verified that. Give me one second.
The facts that were communicated to them. And I do think, though, that the possibility of suicide by cop counseled additional caution on their part. And you see this on the body cam. Of course, they are worried about the concept about the instance of suicide by cop. But that's why they're doing the additional investigation of walking around the outside of the house, yelling into an open window, giving Mr. Case every
They saw
opportunity
empty
to let
beer
them know that he
cans
is alive
and a
and inside,
notepad, which they perceived to be a suicide note. It was a
seems to me that there's some
perception.
confusion in the case law, and I mean, I think there was some sloppiness in the standard in this case. Does Montana have some separate community caretaker exception or something that it calls a community caretaker exception that's really equivalent to our emergency aid section from Brigham City?
Yes, Justice Barrett. I think that's when the Montana Supreme Court discusses the community caretaking exception, I think they're folding in Brigham City. There was some confusion, I agree, in the standard, but it's an exigent circumstance exception to save human life. And I think that's essentially what they did.
Okay.
Yeah, that's the problem, is that like people are putting in the comments, perception is problematic, right? The officers knew this person. They spent 40 minutes trying to enter their dwelling. They were looking through windows. They never staged. They never made sure medical personnel were there, all on the assumption that this person was actively or trying to harm themselves. And also that this person had, I guess, previously attempted suicide by cop. If you can't tell me that there's some problems and nuance in this scenario, you are not listening to this case.
Well, the court is admittedly.
I'm not
using
attacking. I'm
imprecise
just saying
language.
like that
What
generally.
I think is what's important is that the court is applying the totality of the circumstances, and it's making sure the scope and manner
Agreed,
of the search
legal
is
cap.
reasonable. And of course, as my friend was up here and the court was asking questions, pointed out that the court does
thank
use
you,
some
everybody.
language mirroring at times in sort of the more specific application of the test that mirrors reasonable suspicion. But this court has done that in TLO and the special needs cases. And so what the court is looking to do is make sure that the scope and manner of the search are
Thank you so
reasonable
much,
and balancing
everybody.
the privacy interest at
I
stake.
actually don't see any them addressing the reasonableness of the manner in which this occurred. And I pointed to things. Justice Barrett was right. You're not going to send medical personnel into a room with an armed person, but you do call medical personnel to make calls or to talk to someone who's suicidal on the phone. It happens quite often.
They could do that. Now,
You can put a megaphone out there.
I will point out the time exigency here is that they did call medical personnel one case after the entry and he had been shot, but the officers here.
Yes, after he had been shot.
After.
They had a great
After.
probability of knowing that he was seeking to be suicide.
They weren't even there.
There's no indication that EMTs would be able to talk down Mr. Case. In fact, Chief Sather, who had known Case for 30 years, testified that based on prior incidents, he actually thought that he could talk Case down and get him out of the house. It was only after they received the reliable indicia that Case had actually suffered a
You
gunshot
can't
wound
tell me that
the
this
chief
case is not
arrives and says we have to go in.
suspicious.
Am I right, just to go back to where you ended with Justice Barrett, that you are not equating the city of Brigham standard with our Terry stop standard?
Correct.
You think that those are two different things?
I think they're two different things.
Okay. And as to the difference between the city of Brigham standard and the probable cause standard, is your position that the city of Brigham standard is laxer, or is your position that it's just different?
I think it's more flexible. And I think it answers a different question. So as the court recognized when my friend was up here earlier, it's probable cause isn't just about reaching a specific threshold. It's fixed to criminality. But objective reasonableness says, given the totality of the circumstances, would an officer taking a specific action be reasonable? And I think one way to think of it might be probable cause is a single determination about whether a quantum of proof has been satisfied. But objective reasonableness, as in this case, can be a progressive analysis. And what I mean by that is when officers...
So it would help me, I think, because that's a lot of words. And like, what's the case in the gap between the two? Like, what is it where a police officer would not have probable cause but can satisfy the Brigham City standard? What are the kinds of things you're talking about?
So I think if you take this particular case and subtract perhaps Mr. Case's history, which I actually think supports
It's
the
just
officer's
on the
reasonable determination,
expectation
or if they had
of what
not,
a reasonable
obtained the other
person
reliable indicia. So if Case's
would
ex-girlfriend
do in that
had called him,
situation.
she had heard the cocking of the gun, heard what she thought to be a gunshot, police arrive, they knock.
Like me in that situation, had I had thought something was going on as an officer, right? I'm presuming myself to be an officer in this situation. my first call would have been for medical staging. And maybe that throws back to my healthcare work, but if I'm assuming somebody is hurt or going to harm themselves, I would want to be getting them to the hospital before I would want to be doing anything else.
By probable cause because they're reducing. That was my question to him at the end, which is without the suicide by cop
objective reasonableness isn't bad.
I thought he suggested we did, but it was the fact that the cops also had this additional information that made it less likely, or objectively less likely, that Mr. Case would actually commit suicide.
Well, I think it's important to put the suicide by cop in context. So some of what's happening at the scene.
But if it's objectively less likely that he's going to commit suicide, then the question would be, why did they enter the home?
I think his cop talk of Sergeant Pasha is clearly very concerned about suicide by cop. The context of suicide by cop first came up when Case was on the phone with his ex-girlfriend, and he says, "I'm going to kill myself," and she responds, "Well, if you threaten that, I'm going to have to."
I
call
don't
the
think
police."
that they
And she
necessarily
says,
handled it
or he says, "I'll shoot it out."
wrong.
Chief
Maybe
Sather
their
responds
intention
to
was
Sergeant
good,
Pasha's concern
but
about
it's
that
sort of the
comment by
outcome
saying
of
he
like
doesn't have the guts.
they
So I
already
think
know
the
that this
dissent is
person is
incorrect, that the
obviously
Montana Supreme Court is saying
unstable.
all the officers believed. And our point is
Why
certainly
would you
suicide by cop
escalate
was
the
a
situation,
possibility,
I guess?
But that was, I think the officers ruled that out based on his escalating history of violence going back to 2015 and the incident that was 18 months earlier. And particularly once they found the note, Chief Sather is convinced that he actually
Keep saying
has hurt
they
himself
found a note. Everything that I've seen on it says that the note was not a suicide. It was a presumed suicide note.
In terms of the test of reasonableness, we admit that objective reasonableness is an easy test, but it may not be an easy rubric to always apply, where the court is taking the privacy interest versus the nature of the exigency. But I think the court just did this in Barnes. And the court admitted that it's a fact-bound morass that demands careful attention to the facts and circumstances, including the facts and circumstances leading up to the climactic moment. And the court has to consider all relevant circumstances.
I mean, the simple fact is you can't save people who don't want to save themselves. I applaud their efforts in, I guess, trying to make sure nobody from their community is harmed. But short of violating his Fourth Amendment,
versus the use of deadly force,
and in my opinion, they did here.
Makes sense here. The application of it makes sense. And
you can't protect people from themselves all the time.
City,
we want to. You
in
can't.
terms of hybrid scenarios that have been brought up,
I'm so sorry. I have a wire cutting
Brigham City and
into me,
other
so
cases that involve underlying criminal activity recognize, though, that first responders are first responders first. When they arrive on the scene of an emergency,
not necessarily, but certainly thresholds.
Their first instance when they respond to
I
someone
feel
yelling
threshold
help
needs
is
to be
provide
established
aid to someone in need.
Because there's
they can worry
a
about
lot of
arresting,
potential for abuse
someone
in
for
this.
a crime or other criminal activity later on. We treat hybrid cases the same as all other exigencies. And what's important to remember is, as I was
get a court order for an
articulating to
involuntary
Justice
hold.
Kagan, is the objective reasonableness standard allows a progressive analysis. And so when the officers arrive and do a knock and announce, it may not be objectively reasonable right away for them to go through the front door, but it allows them to go around the curtilage, to yell through an open window, to take progressive steps to alert the individual and give them every opportunity to respond and let them know that they are okay. And I don't think that probable cause allows that sufficient flexibility and doesn't differentiate between going through a door and breaking down a window. Whereas the Barnes standard and the reasonableness standard differentiates between the facts that make it reasonable to handcuff a suspect versus to tackle a suspect or to use deadly force. And that's why we think that the Montana Supreme Court appropriately applied this court's test in Brigham City. This court meant what it said in Brigham City, meant what it said in Fisher, that officers may enter when they have an objectively reasonable basis to believe someone inside is in need of immediate aid.
Thank you, Counsel. Justice Thomas. Justice Alito.
Counsel, our entry into the home cases, and it's been paramount that a person's home, we don't enter without a warrant except in recognized exceptions. And I understand the instinct
Somebody's
that
talking
says
about
that,
the 72-hour hold.
We don't want someone in real need.
It's because
not to have the
they have
police
to have a
enter quickly.
probable cause hearing, or
But
at
we're
least
always
in most
balancing
places,
interests,
within the
aren't we?
72 hours, or at least
And
immediately following.
Not requiring enough proof also
And it's
costs
based on
lives.
like
Petitioner cites
substantial
reports that
reasoning
people
behind
with
why you're
serious
doing this.
mental
It's a
illness are
medical
16
professional making this
times
call,
more
not
likely to
just
be
some
killed by
fucking
police during a police encounter.
backwater cop.
An
Like, I'm not trying to
investigation found at
disrespect
least
officers here,
178
but
cases in a 2-year period where calls for help.
I'm gonna hope that's
not a crime,
a doctor making that
like a
call.
9/11 call or a wellness check, resulted in the police shooting and killing the people they were called on to assist. It's a fine
Sure, yeah,
balance,
macaroni. It
but
is.
Shouldn't we make
You
sure
could
that
say
the
that
courts
it's
below
subjective, but
are
generally, if a
at
person
least following the right
being
standard?
held is somebody
So
showing
keep telling
levels
us
of
that
psychosis,
that
which
this
are
state
medically
is,
measurable,
despite
extreme
using words that
depression,
sound
medically
very similar to
measurable,
reasonable
an
suspicion,
intent to harm themselves,
despite a
medically
case,
measurable.
Lundgren, that says it's less
It's
than a
not
terror
that
stop.
cut and dry, that it's just
And
subjective,
there's
like
some
doctors
value in
make shit up.
clarifying
That's
what we
not how
have
that
said
works.
the standard is. If you're asking us to describe what
They
the
have
quantum of
criteria and
proof,
standards that they
sounds
have
like
to
you wanted
follow.
us to accept
I agree,
what
involuntary holds can
the,
still be problematic.
the
However,
Solicitor
that's
General
why
is saying
you have to
some
have a hearing.
possibility is enough. But that's never been the standard. It's a
I agree,
reasonable
Wallace.
suspicion, reasonable belief, not a probable belief.
So I agree that clarification from the court, and I think the court can clarify that it meant what it said in Brigham City, it meant what it said in Fisher, and that an objectively reasonable basis is what it is.
And it's not reasonable suspicion.
It's not
Macaroni,
necessarily
we're not
reasonable
even
suspicion.
talking
I
about
think
involuntary holds, so you can take that shit somewhere else,
the standard can
or
look like reasonable
stop giving me
suspicion,
shit to
and in
fight
some
with you about.
cases, the flexibility makes it look more like probable cause. But there's where we're getting to the degree of certainty of the exigency.
No, they
It
haven't
takes it-
mentioned
the-
that
And you
either.
want it to be reasonable
That's
suspicion.
a no-knock warrant as
the
well as
objective reasonableness standard is the
them
most
going to
faithful
just
to
the
the
wrong
text,
fucking
history, and
place.
tradition of the Constitution. If given a binary choice, we would take reasonable suspicion over probable cause. But objective reasonableness is much more flexible and faithful to the text, and it accounts for situations like this one or others where there is some doubt as to whether an individual is in need.
So we might as well just say what the court below said. It's less than a Terry stop.
Well, I think I'd look to the language in Fisher where the court says officers, of course, are going to have less than perfect information, but that doesn't mean they should walk away from potentially dangerous situations. And all we're asking is that they use their common sense. Officers, as well as reviewing courts, are more than capable of figuring out when the facts don't add up and when an objectively reasonable belief doesn't exist. And I think I go back to this court could apply whatever standard it articulates to the facts in this case to provide ample guidance to lower courts.
Justice Kagan?
I think I'm confused, General, because I thought you told me that the City of Brigham standard is not the same as the Terry stop standard, and that you were not asking for the latter.
It's not. It's not in all cases. The Brigham City standard is the Brigham City standard. In terms of the degree of certainty, it can vacillate between probable cause and reasonable suspicion.
Sure,
The
yeah,
text is just more
Macaroni.
complex than that.
Thank you.
I can agree that they can attempt to hold. That doesn't mean that it coincides with their right to enter your property on just a suspicion that you may be doing something based on a call to the police from your ex-girlfriend. That's the nuance of this situation that, like, I feel like you're trying to equivocate here. That is not equivocal. Yes, they could put you on a 72-hour hold. That still does not give them the right to just enter your home for any reason ever, because if they give them the right to just be like, yeah, we think that they might harm themselves, that has a high potential for abuse by officers. That's the whole problem here, is the nuance level of this case.
Okay, thanks.
Justice Jackson? Thank you, counsel.
I think we're going to hear rebuttals.
Mr. Kobe?
Mr. Chief Justice, and may it please the court. This court should adhere to the objective reasonableness standard for emergency aid entries set out in Brigham City. rather
I
than
don't know who
require what
this one is,
petitioner
I'm
calls
sorry.
probable cause of a danger. Petitioner's theory has no basis in the Fourth Amendment's text, which links probable cause to warrants, not to searches in general. History doesn't support petitioner's theory either. The framers adopted the Fourth Amendment to guard against overzealous criminal investigation, not to hamstring officers from providing life-saving aid to people in need. Yet petitioner's rule would make it harder for government officials to help people in crisis, from victims of domestic violence to older people who have fallen and can't get up. This court should instead reaffirm that emergency aid entries are assessed for reasonableness, a flexible determination that accounts for both the severity of a danger and its likelihood. States are always free to craft their own rules above that constitutional floor, but the Fourth Amendment does not categorically require probable cause of a danger for an emergency entry. I welcome the court's questions.
Should we apply this rule here or send it back?
We think you should apply this rule here. I think there has been some question about the Montana Supreme Court's use of the word suspect in its test, but I would urge this court not to read a decision like a statute, especially because elsewhere in the decision, the Montana Supreme Court said that its test largely mirrored the Ninth Circuit's test, which uses the objectively reasonable basis for believing language, and because it used other verbs elsewhere besides suspect. I think PEDAP 14A footnote 5, they say there was an objectively reasonable basis for finding a danger. So
Not Montana saying they're using the most liberal circuit for their justification. Sorry, I just find that funny.
I would avoid sending it back just on the basis of
It's
that
not good
word
nor
suspect
bad,
or
just
sorry,
it is
and
what
the
it
like
is.
The dissent, when they addressed the dissent's accusation that they were using reasonable suspicion, nowhere did they say, we're not. Would have been the easiest thing to do. We're not using reasonable suspicion. Instead, they said, we don't have to because it's more, it's a different purpose than an arrest. It seems to me that that's not a disavowal.
I do read them to sort of disavow that they're applying a reasonable suspicion
No,
standard.
they
but
said we're not giving open license, but they didn't disavow it.
I think even if you disagree with me about that, the reason not to send it back is the one that Justice Alito articulated earlier, which is if you give sort of officers and lower courts the impression that there is any doubt about whether the facts here satisfy the Brigham City test, I think that's going to lead to a lot of confusion and a lot of concern that officers can't make entries based on the type of information that they would think they could.
If we apply it here, are we ignoring the countervailing factors of why they shouldn't have gone in? We have a number of officers on tape saying he has no guts, he won't kill himself. We have others saying...
Sotomayor clocking it with shit from the body cam.
There's no attention paid by the officers to trying the father or to calling a doctor to call out to him, not go into the place. All they decide to do is go in. Are we...
Clocking the body cam, he won't really unalive himself. Then why are you entering the home? That is not objective reasonableness, nor is it probable cause. If you have an officer literally clocking that on the body cam, that's wild.
I think the call and the suicide note and the empty holster. So I think this is a situation in which there were risks of multiple outcomes, and the fact that they articulated a concern about one of those outcomes doesn't mean there wasn't also an objectively reasonable basis for believing that the other outcome might have happened as well.
You haven't
So I take
even
it that
been
you
here?
agree with Montana that the degree of certainty can vacillate under the Brigham City test, and that that's really the work of your sliding scale. Is that right?
I think that's right. What I would say is it's not so much like in one case you need probable cause, and in another case you need reasonable suspicion. Our point is just that there is not a fixed prescribed quantum of certainty of danger that needs to apply in all cases.
That's
the
what this
amount
case
of
is
information,
about,
the
is
reliability
the-
of information,
the
the corroboration
threshold.
of information that an officer would need to make their entry
Oh, thank you so
reliable
much
in
for
one
the follows
instance
and the
may not
likes.
be the
I
same as in
appreciate
another.
Those are the
everybody
key
so
factors.
much.
That would it be helpful for us to kind of say that kind of thing? In other words, I understood your sliding scale to have a matrix essentially that related to the severity and the amount of information.
I think so. To be clear, I think the sliding scale, it's just a
I
metaphor. We
usually
don't
do
mean
these
sort of
every
strictly
week
formulaic
when
or
they're in
matrix or anything
session,
like that.
so
just that these are relevant
I
considerations.
try
that
to
can
do
make,
this at least once a
entry
week.
reasonable.
As the docket becomes more clear, I'll have more lives that I
I
announce.
understand lots of different facts can lead to an objectively
I didn't do
reasonable
yesterday
basis.
because,
Okay.
frankly,
And
it
it's
just
almost
wasn't. I know a
impossible
lot
to
of people were
catalog them
super
all.
interested in it. It just
But on the
wasn't
other
my
end,
thing.
on the severity, we said in Brigham Young what we meant, Brigham City, sorry. I am tired. That it has to be a severe risk of harm to the occupant.
Gavin,
I'm
if you can
paraphrasing,
give me
but
one
life or limb is the
Jackson
classic
quote,
formulation
I'll
of
believe you.
Blackstone. That's
Type it quickly. You
the
have
severity is the
30
severity.
seconds.
There's no sliding scale. You don't get to go in with lots of evidence to deal with a hangnail.
I absolutely agree with that. There's sort of, I mean, I think what we would think of for the sliding scale, there's an outer bound on the sliding scale formed by Brigham City's use of that serious injury. But not all serious injuries are alike, and our point is that based on sort of the degree of the exigency, the severity of the injury being complained about, it may be reasonable in some instances for officers to rely on less information or less reliable information, and in other instances, it may be reasonable, it may not be reasonable to rely on so little information. So that's
Do you have any thoughts about the common law of necessity?
Less reliable information? When and where and how? And where's the threshold? I want to see what comes out of this. I'm fascinated by this.
Yeah, I think our point is that that's a useful guide.
Like, just fuck
for
it.
the reasons that Your Honor articulated. The fact
Your
that,
ex-boyfriend
private
who
individuals
hates
were
you
able to
can call
enter
you in
when
for a
life and limb were at
welfare
stake.
check
We
at
provide
2
some helpful
a.m.
guidance about what the
and
framers
knows you're
thought
armed
was
and
reasonable
lands
here.
you a
I don't think that
suicide
we
by
think of it
cop
as a
because you didn't
direct
know they were
one-to-one
coming in the
analog.
door.
But I don't really think it's our burden to come up with a direct one-to-one historical analog
'Cause if
here,
you're
given that we
armed-
have the text of the amendment on our side, and it's really petitioner who's asking to graft onto the Fourth Amendment's reasonableness standard.
People say this
uniform
can't be
probable cause
abused, but we
requirement
see,
that
like,
is not compelled by the text of the amendment.
statistically time and time again in no-knock warrants that like
officers have to have more
people end up unalive that weren't supposed to be.
I think we would object to it for a couple of reasons. I mean, one, I think because reasonable suspicion is a standard from the criminal law, just as probable cause is, for the reasons that Justice Kagan
thank you so much. I appreciate everybody, the heart means, the likes, the
just
follows.
pegging it to
like,
any one of these criminal investigation standards, I think, does more harm than good.
But why isn't that? Isn't that familiar? I mean, they're used to those standards, and so I appreciate that they do it in the criminal context when they're looking for crimes. But they understand, I would think, the difference between probable cause and reason, and I'm more focused on reasonable
I'll be right back.
suspicion
I gotta get some
in that
orange juice
context.
real
And
quick.
so why couldn't we just say you have to have more than reasonable suspicion that an emergency is occurring?
Well, 2 points. First of all, police officers may be familiar with reasonable suspicion, but your standard here will also apply to firefighters, paramedics, all of whom may have no more familiarity with reasonable suspicion than with probable cause. And reasonableness is, I think, an easier standard to understand. And second of all, I do think, just given how varied emergencies are, it's best not to sort of set a floor at reasonable suspicion, just because this court can't really predict all of the manner of emergencies that could arise. And rather than hamstringing courts or officers with setting a floor on this, better to just stick with the objectively reasonable basis test from Brigham City.
Thank you.
Justice Alito?
In Brigham City, I'm quoting from the SG's brief. One way to conceptualize the emergency aid situation is that the basic requirement that the police have an objectively reasonable belief, i.e. probable cause, does not change. But the object of the probable cause does change. Rather than requiring an objectively reasonable basis for an officer to believe a crime has been or is about to occur, the officer needs an objectively reasonable basis to believe that an emergency need for assistance exists. Have you changed your position?
Yes, after the court's decision in Brigham City, which used the objectively reasonable basis language but did not draw that connection to probable cause that we had sort of floated in a footnote, we did rethink that. And in Cornelia, our brief 5 years ago, we made clear that our view is that probable cause is not the correct standard.
May not be, but Brigham is.
Yes, Brigham City is the correct standard, and we sort of disavow that equivalence that
And reasonable suspicion is not.
Not the correct standard either. Objectively reasonable basis, just from Brigham City, is the correct standard.
Okay.
So did they just admit that the case should be remanded to apply at least objective reasonableness?
Decades and decades old. As the court has repeatedly said, at the very core of the amendment stands the right of a man to retreat into his home and there be free from unreasonable government intrusions. In Payton, the court said that the Fourth Amendment has drawn a firm line at the entrance to the house. And so these rules do not require, if you apply a probable cause standard, some kind of fundamental tweaking of Fourth Amendment jurisprudence. We think that they are a natural application of these basic Fourth Amendment principles. I would also stress that in a lot of these situations where the emergency aid exception arises, you have not just potential safety implications, but also criminal implications. Think of domestic violence situations or the situation that the officers faced here. And so having a parallel standard of probable cause to think a crime is being committed, but also probable cause to think that somebody is seriously injured or imminently threatened with such injury makes good sense. Conversely, if you adopted a standard that was a sliding scale, as the government has suggested, or a lower standard for the emergency aid exception, there is the potential for abuse. You could backdoor your way into a criminal investigation. I just note that while the state now has expressed concern about applying a probable cause standard, in its brief in opposition, it noted that a significant number of lower courts apply a probable cause standard, even, and they say it's functionally a probable cause standard, even if what they say in terms of the standard or the words used is different. And the court didn't suggest that that was a problem or that stopped police officers and other first responders from going in and helping with an emergency. And so we don't think that applying a probable cause standard, which is the default standard, would prevent officers from stopping.
This is rebuttal. It'll wrap up pretty soon.
Or intervening in an emergency. On the common law, because Justice Gorsuch asked about that, I just note that the cases that my friend features in the respondent's brief, best cases presumably, do say that the defendant or the potential tortfeasor has to be right. In Scott v. Wakeham, the court says, and I quote, "The question was not whether the defendant sincerely believed he was right, but whether he was so." So this reasonableness clause is a restatement clause. I think the more fundamental point, though, is that when you are asking about constable authority, the focus is what the rules that governed constable power and what they could do are the cognate rules. And the closest one is the affray rule. It actually applies to the same set of circumstances that were at issue in Fisher and in Brigham City. Both of those involved what I think the court called a melee or a fracas that is essentially an affray. And we know what the common law thought about that. What the common law thought was that the constable had to see or hear the affray if he wanted to break down doors and part the affray. That standard is fundamentally inconsistent with a standard below probable cause. The necessity defense and none of the other specific rules that the state and the United States outline supports a standard below probable cause. And so we think that the common law is more supportive of our position than theirs, and that it echoes not just the language in Brigham City, but it also underscores other exigent circumstances cases like Minnesota v. Olson, where the court has said that probable cause for an exigency is essentially the correct or the proper legal standard.
Oh, thank you.
And also in Santana, which involved an exigent circumstance, after all, hot pursuit. And the court applied a probable cause standard, not just for the underlying crime, but to think that an exigency existed. The last thing I would say is that the United States says that reasonableness is an easier standard to understand than probable cause. But as Justice Jackson observed, probable cause is as settled a formulation as you're going to find in the Fourth Amendment. It's a standard that officers have applied, that the courts have developed over decades and decades. As the court said in Dunaway, the familiar threshold standard of probable cause for Fourth Amendment seizures provides the relative simplicity and clarity necessary to the implementation of a workable rule. A balancing test, particularly a sliding scale test, will not only be unfamiliar to first responders, but particularly unfamiliar to officers and other first responders.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until...
Okay. So a lot has gone on. We've watched 2 oral arguments today. I am pretty worn out. However, if I could probably do like 15-20 minutes if anybody wants to come up and just ask me a few questions. But this has certainly been a very interesting day. Both the Robinson and Louisiana v. Callais case we had earlier, which is about racial gerrymandering. And then we also had case v. Montana, which is about, hey, can police just enter because they think you might hurt yourself? Are both very interesting cases. So in the first one, I'm going to tell you, it's probably, I know for sure Alito's going to dissent. I think Kavanaugh is going to dissent. I think maybe Barrett and Thomas. However, everyone else I think is up for grabs. I didn't hear a lot out of Roberts. He may just be kind of doing the stoic and silent, but I think Gorsuch had enough argument in him that I could say I don't think he will. And everybody else is up for grabs. Now this one, I think that essentially all they're going to do is probably reverse it and say you need to apply basically the Brigham standard is probably what is going to occur. Now this is just speculation. Please don't take any of this as this is absolutely what will happen, because I could be wrong and I get it wrong. So that's just my guess. What's up, Lawless?
I just came to keep you company. So, yeah, the House entry I'm torn on, but I would say that if there weren't limitations to entering under the lower standard with exigency, then they should have to use probable cause.
I think that a reformulation of probable cause, at least in the terms of like we talked about with like this like objective reasonableness on like a civil sort of standard because there's not a crime occurring, I'm even okay with that. But there has to be some level of like consistency and not just like any old motherfucker can call and say, I heard her do this. I think she's going to hurt herself. And like I used the example earlier, like I'm in the shower, you know, and I'm not hearing my door and I come out and like people are in my home that I don't know. The first thing I'm going to do is like get my firearm because I don't know what to do. And then guess what happens? Something bad is probably going to occur. Yeah, we see this with no-knock warrants over and over and over again, that they like, I think at least for like just the simplicity here, at least at night, no-knock warrants should not be allowed to exist, except in very rare and highly scrutinized situations. But I don't think that those should be a thing at all. But yeah.
But I think judges have to sign off on night service, right? And no knock.
Yeah, it varies from state and counties and da 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 da. But usually, but it's one of those like not all the states have consistent rules. But yeah.
And my statement about limited powers only addresses if they uncover a crime unrelated to why they entered, but it doesn't address your point of a standoff or a shootout between a citizen and police. So.
Well, yeah, like my concern with things like this is like, even if you're not adopting like a probable cause, right, which is like clear standards that you need, if you're just at least adopting something in the form of like where you can sort of like roll this over, like you know, there's a reasonable belief a crime has occurred, is occurring, about to occur, evidence of the crime can be found at that specific location, and you know, like you have some sort of overlay of this into like where you're talking about mental health and other things like that. I can be okay with that. I can respect that. But it's when you get to like where they're just doing whatever based on a hunch that I have a serious problem with. I don't inherently disrespect or not like police officers. I think that they have shown that they can be problematic though, because they're trained to see and expect the worst outcomes. So at that, and it's by design, that's what they're there to do, but that also doesn't help somebody that may be in a more sensitive situation. What's up, Cassidy?
Hey, so thanks so much for bringing me up. I just wanted to express my concerns about how this will impact things going forward, especially with what we've been witnessing these last few months, especially with regard to Chicago, for example. Okay? What is deeply concerning to me is that by using this ruling, and that's what I'm concerned about. Of course, they have not ruled on this case yet, right? And they might send it back, which would be beneficial. However, if they don't and they decide to make a ruling on this, what's to stop them going forward that's saying, hey, we think this is, a probable cause situation, and to anyone. And this is a direct violation of everyone's Fourth Amendment rights.
Well, so the argument being made, right, is that they're trying to apply it under the strictest of terms, which is the Fourth Amendment only applies to crimes, right? So here's what I urge everybody to know and understand about when you're dealing with ICE. I want you to be very aware of warrants. I have a video on my page about ICE warrants. ICE warrants are often not issued by a judge. They don't entitle you to ever enter a home or a car. They can stop you and you can simply say, I'm invoking my Fifth Amendment right to remain silent. You don't have to answer any of their questions. You do not have, as long as it's not a judicial warrant, they have no right to enter your home.
Well, exactly. But if they do use this as a ruling or a basis, much like they did with, they can just profile and take anyone in. That's my concern about where this might lead to.
But ICE are not traditional officers in that sense. So it's a little bit different on that overlay there.
Plus, they have expanded powers in the 100-mile zone and other areas.
Yeah.
So they could try, but they're not a traditional response mechanism. Now, when it comes to crossover with the National Guard and what they're allowed to do and not that potentially, but ICE are not officers in the traditional sense of they're responding to a call. So they would have a very high threshold that they would have to meet there. I mean, I have my own issues with fucking ICE and all, it's fucking crazy. But yeah, I would say I wouldn't be as concerned about that as I would be about regular officers.
Well, that too. Yeah, that too. Because, if they establish the precedent that it's okay, that they can just make this call, anybody could say, oh, well, I think that this person might be a danger to themselves,
Yeah,
that's what's concerning to me, because how did they make that definition? For example, this case, they said he had a note. There was no note. You know what I mean? That's where I'm concerned.
So they kept bringing up that note, and at least from everything that I read, and there are so many amicus briefs and other things that get filed, I wasn't able to see that he actually did have a note. It was a notepad that they suspected was a note. That's what bothered me about when he kept referring to this note, was that I was I did some reading on this and I didn't see anywhere that it was confirmed that this was a note. I saw that they suspected it was a note, which are two very, very different things.
Right, and suspicion does not make precedent. That's where I was, that's what's concerning.
The next problem is, what if the tip had been anonymous?
Exactly.
Not from a girlfriend.
It's swatting or something like that. Yeah.
Yep.
Well, and that's the thing is so agree with me, disagree with me. I only have about 130 people in here. This is where I lose most of my lefty friends. I have the same issue with red flag laws. A lot of them operate in the sense that somebody you were, say your ex, or somebody that's in a close relationship with you, right? They can make a call and say, this person wants to hurt themselves or others. And then they get to come in your home and disarm you before you've ever been able to present your case to a judge. And then you have to get a hearing scheduled, and then you have to get all your stuff back. And while I can certainly see that that is beneficial in some circumstances, overwhelmingly, it still is a violation of your due process rights. So like, that's where like all of this sort of comes filtering down, is like, once you're willing to like do these sort of like little compromises where it's okay here, how far does it go to where it's not okay? And that's what I
see. That's my
case.
concern. That's my concern. Like, where is the threshold? Where does it stop? Because if you keep pushing back the goalpost, eventually there will be no more goalposts.
Yeah.
And then everyone's Fourth Amendment rights or their due process rights are violated.
Yeah.
Regardless of citizenship, etc. This is a constitutional crisis in the making. That's what I'm concerned about.
Yeah. No, I agree. And like, I honestly think on this one, what they're probably going to do, I see the most likely outcome, at least based on the questioning and the way that they were sort of talking. I think it's likely that it's going to probably be per curiam, that they're going to reverse it back to apply objective reasonableness to the Montana Supreme Court. That is my best guess here. There may be a dissent or a concurring in part. I'm not sure yet. But if they sort of revisit this sort of Brigham and create a new standard, which I don't think they will. I don't think that's what they were leaning towards. I think it's interesting. I don't see them loosening this, but I also think that they need to establish more, to your point, what that threshold is. Like,
well, see, and I'm hopeful, but I'm not optimistic. Does that make sense? Like, I am hopeful that that's the case, but these last many months, especially with regard to a lot of the rulings that have been made, it does not give me a lot of optimism. I think that's where, I see where you're coming from. I'm hopeful, but I'm not optimistic, because people have just been using exigent circumstances to usurp these constitutional amendments and laws. And that's the thing that concerns me the most, because if you don't have a threshold, a hard line in the sand, and they keep pushing back the goalposts, where does it end?
Sure, yeah, and I agree with you there. Like, I can tell you 1000%, I'm for finding some form of probable cause that applies in these sort of like medical and odd situations that are more of a civil matter than, I'm for them defining that. I have zero issue with that. The question is, will they? Do they think it's enough that they need to like make a new test or standard? I doubt it. I think they're going to stick with the objective reasonableness. And I would have been fine in the sense that if objective reasonableness would have been applied in this case, but it wasn't. It was just like this reasonable suspicion, like sort of bullshit that the Montana State Court or Supreme Court was, diddling with, that was absolutely crazy. But like, yeah, the nuance of this case is extensive. It's the literal fact that they were there for 40 minutes. They were knocking on doors and peering in windows. They saw a note that they thought was a shmuasai note. They saw a gun. Okay, yeah, that happens. People are armed and they have guns in their home. They enter the house after 40 minutes with no medical staging for backup on somebody they presumed. And then they clock it with the cop going, he's not going to do anything. So why did you enter the home? That's what bothers me the most about this.
Yeah, the facts of that case don't seem to support the best case of the issue. But to your point earlier, now if they allow a standard for police to enter under exigency, anytime someone's in your house, you don't know if it's a cop that has exigency or a burglar, threatening.
That part right there. Exactly.
Yeah.
Do you have a right to defend yourself? Here in North Carolina, we have a castle doctrine. If someone enters your home, you are allowed to presume they are there to cause imminent bodily harm. Yep. But if it were a cop, do I have to figure that out in the dark? Do I not have a right to shoot?
and that was my biggest problem is like I said earlier, like if I'm coming out of the shower and like I'm taking a shower late, like let's say it's midnight, right? And like somebody's like bursting down my door because trust me, like you don't like they're not unlocking my door with a key. Like they're busting in my house. Like it's not easy. It's not an easy process. Or they're breaking a window or something that like burglar-ish would do, right? And then wonder why somebody getting out of the shower at like say midnight or whatever is armed. Yeah, no, I'm not figuring that out in the dark. Like I'm going to arm myself and protect my home and my kids. Like that's crazy.
And I want everyone there
right.
to know Cass showers with a firearm. She lives in Texas, and that's what they do.
Oh, I have you don't have a shower gun? Listen, I literally, and I know this sounds like a joke, but it's really funny because somebody was telling us one time in a live, me and a friend of mine, that they had a toilet gun, and I'm a firearms enthusiast, so I was like, hell yeah. But it was hilarious because I told him, I was like, you know what, I'm gonna run on that. I'm gonna run on Cass Mayor for Texas Toilet Guns 2024. Everybody would vote for me. I would get every single vote because whether you're a liberal, whether you're a conservative, it does not matter. Everybody can agree that you are most vulnerable when you are dropping a deuce. Toilet Guns 2024.
So carry a deuce when dropping the deuce, huh?
There you go. There you go.
Yeah.
I mean, you can like them or hate them. Like, and I mean, if you don't like gun, like we can get you some pepper spray. We can get you one of those shooters that shoots the t-shirts. At least you'll cover their face while you get away, or at least pull your pants up. Like, it's great. Toilet Guns 2024, baby. Or, well, I guess it's 2026
leaf blowers
now.
full of glitter.
Yeah, 2026 now, but yeah, that was my thing then. But anyway, guys, I am so sorry, but I'm just exhausted because I've been live since 9. Do we have any like final comments or final follow-up?
I appreciate
you sharing. Yeah, I appreciate it as well. Thanks for sharing it. It was very, very impactful. It gave a lot of insight, so I appreciate it.
Yeah, no problem. All right, guys. Everybody have a good
night.
one. And thank you so much for liking and supporting. I appreciate y'all. Bye, guys.